Evening, everyone. This is the March 19, 2024 meeting of the Egg Harbor City Municipal Land Use Board. And in compliance with the Open Public Meetings Act, adequate notice of this meeting was provided by posting on the City Hall bulletin board and by notification to our newspapers of record. And I asked Donna to please make this announcement part of the public record. We have this is our reorganization meeting. We have not met in 2024 yet, so applicants, I would appreciate your indulgence to allow us to get through our reorganization, and we'll get to the business at hand as soon as we can get this off of our plate. We're going to go into the oath of members. We'll grab John on the back end when he gets here, and we'll just have to do him separately. But we have Gladys Torres, myself, Mike McKenna, George Frick, Stefania Keener, and should we swear the council people in, Kim Hesse and Carl Timbers?
Yeah, we need the following people to stand at this time. Mr. Garth is not here yet. Ms. Hesse, Carl Timbers, Stephanie Akuner, Gladys Torres, George Frick, Michael McKenna, and Jack Peterson.
Anybody in the audience, you guys come to so the camera can pick you up so people watching from home can see you. I'll break this down in the easy bites. And after I say I, you're going to state your name. And then when I get to the part where I say the duties of the office of, right now, you're all just members. No one's been elected to any position yet. So you'll just say member. All right. So raise your right hands. Mr. Peterson, you're going to put your hand on the Bible representing everyone else.
Yes, ma'am.
I
Jack Peterson.
do solemnly swear
Do solemnly swear
that I will support the Constitution of the United States
that I will support the Constitution of the United States
and the Constitution of the State of New Jersey,
and the Constitution of the State of New Jersey,
that I will bear true faith and allegiance
that I will bear true faith and allegiance
to the same
to the same
and the governments established
and the government established
in the United States
in the United States
and in this state,
and in this state,
under the authority of the people,
under the authority of the people,
and that I will faithfully,
and I will faithfully,
impartially, and justly perform all of the duties
all of the duties
of the office of member
of the office of member
of the Planning Board of Egg Harbor City,
Planning Board of Egg Harbor City,
according to the best of my ability.
according to the best of my ability.
And you may add, if you choose to, so help me God.
So help me God.
Congratulations.
Thank you.
Well, that's actually a very good comment, and I'll comment on that later, but thank you for bringing that up.
Congratulations, everyone. Thank you.
Thank you.
Donna, if we could, a roll call, please.
Mayor Petty. Here. Mr. Peterson.
Here.
Mr. Timbers.
Here.
Mr. Walker.
Here.
Mike McKenna.
Here.
Mr. Gore. Mrs. Torres.
Here,
Mr. Keener.
Here.
Mr. Frick.
Here.
Engineer Ryan McGowan.
Here.
Attorney Carol Pola. Here. And Secretary here.
We should have enough voting members then to appoint professionals. Legal counsel, land use board appointment. Is there a motion to appoint? Carol Roloff? Second. Motion second. Roll call, Donna, please.
Mayor Petty.
Yes.
Mr. Peterson.
Yes.
Mr. Timbers.
Yes.
Mr. Walker.
Yes.
Mike McKenna.
Yes.
Mrs. Torres.
yes,
Mr. Keener.
Yes.
Mr. Frick.
Yes.
Thank you very much. I'm just going to take one brief second. I'm Carol Goloff, for whoever, anybody who hasn't met me before. We started the meeting. My daughter Rachel is also an attorney. And Mr. Timbers asked a very, very good question that I'd like to point out, just so we're all speaking the same language going forward. Mr. Timbers asked about the differentiation during the oath of planning board and zoning board. And it is a very commonly misunderstood lingo. In towns that don't have a joint board, we have a planning board and a zoning board of adjustment. When you have a joint board, I don't like it, but the law calls it a planning board. And depending upon the application, only certain members are allowed to vote on certain decisions. And if you're on the planning board only, and we'll talk about in depth about that when it comes up in problematic, if you're not allowed to vote on a zoning board issue because of your class, I'm going to be asking you to step down, stay mute, pretend you're not here. But even though it's really a zoning board function, we still call ourselves a planning board. But you really are two different boards, but we don't say that anymore. So thank you for bringing that up. It's a very important distinction.
Carol, we get a buy one, get one with your daughter.
Yes, and despite the fact that she appears very young, Rachel has been coming to planning board meetings with me since 4th grade. We represent a number of boards, and she knows what she's about.
Glad to have you. Welcome aboard. Thank you very much. Planner and engineer. Make a motion. Your second? Second. Motion second, the roll call, Donna, please.
Mayor Jim Patty? Yes. Mr. Peterson?
Yes.
Mr. Timbers?
Yes.
Mr. Walker?
Yes.
Mike McKenna?
Yes.
Mrs. Torres?
Yes.
Mr. Keener?
Yes.
Mr. Frick?
Yes. And secretary, she needs no appointment, but she does it all, and we appreciate it very much. But I make a motion to return Donna second as a secretary. Everybody called, and I hope she's not pestering you about the meetings, but she's anxious to make sure everybody's gonna come. Election of board officers, is there a nomination for chair?
I'd like to make a motion for Jack Peterson, Chair.
Second.
Any other nominations? All in favor?
Aye.
Anyone opposed? Motion's carried. Thank you. Ladies and gentlemen, I appreciate your confidence in me very much. Co-chair.
Motion for Todd Walker. I'll second that.
And second, any other nominations? All those in favor?
Aye.
Anyone opposed? Motion's carried. Congratulations, Todd.
Thank you.
Meeting dates as distributed. A motion on these meeting dates. Any questions? If not, a motion to approve meeting dates is listed.
So moved.
Favor, please say aye.
Aye.
Anyone opposed? Motion's carried. Thank you. Newspaper ads, Press of Atlantic City and the Hamilton Gazette. Is there a motion?
Motion. Second.
All in favor, please say aye.
Aye.
Opposed? Motion carried. Thank you.
Chair, might I ask a question about advertisement? A lot of boards are now thinking about adding, I don't know if the city has a Facebook page, adding that also. So if there's a snowstorm or something and there's no time to get anything in the paper, or there's a cancellation of an application unexpectedly, posting it on the Facebook, I don't know if.
Yeah, Donna actually has access to that, so if
Wonderful.
the
Yeah.
chairman so chooses, she
Yeah.
can certainly do that.
I would add that as a
So
part of the
can we amend the motion then? to-
Absolutely.
Okay, so we'll amend the motion and who moved it? Mike. Okay, and second, all in favor, please say aye.
Aye.
Anyone opposed? Motion is carried. Thank you. Thank you, Carol. Minutes of December 19 meeting,
So move.
your second,
Second.
all in favor?
Aye.
Anyone opposed? One abstention, I was absent. No resolution, so then we will move into the business for this evening. Application 2024-01, Land Use Board, Egg Harbor City Partners LLC, 10 Philadelphia Avenue.
Good evening, Mr. Chairman, Mayor, members of the board. My name is Michael Lario from the firm of Nemat Davis and Goldstein. I apologize for the principal of the applicant, who's going to provide some operation testimony, has some vehicular issues this evening. He is on his way. He's not going to get here probably for another 20 minutes. I know there's another matter on the agenda for tonight. I don't want to waste any of the board's time. So, Mr. Chairman, if it's all right with you, we're happy to wait out and
Okay.
take a secondary position.
That'd be fine.
Thank you, Mr. Chairman.
Thank you. Replicate Mark, if you're, John, you can be sworn in if you don't mind. Carol has your-
Better being sworn at.
Not introducing myself again, you're just gonna have to guess who I am.
I figured it out.
Raise your hand. I, John Garth,
I, John Garth,
do solemnly swear
do solemnly swear
that I will support the Constitution
that I
of
will
the
support the
United States
Constitution of the United States,
and the Constitution of the State of New Jersey,
and the Constitution of the State of New Jersey,
and that I will bear true faith and allegiance to same
that I will bear true faith and allegiance to the same,
and the governments established
and the governments established
in the United States and the State of New Jersey
in the United States and the State of New Jersey,
under the authority of the people,
under the authority of the people.
and that I will faithfully,
I will faithfully,
impartially,
impartially,
and justly perform
and justly perform
all of the duties of the office
all the duties of the office,
of member of
member of
the Planning Board of Egg Harbor City,
and Board of Egg Harbor City,
according to the best of my ability,
according to the best of my ability,
and you may add so
so help me God. Thank you.
Congratulations. And we'll move to application 2024-02, Land Use Board, Spread the Gospel, 235 and 243 St. Louis Avenue.
Mr. Chairman, welcome aboard. My name is Mark Friedman. I'm a member of the Jersey. I represent the applicant, Spread the Gospel. Spread the Gospel is located at 235 and 243 St. Louis Avenue. And there's, 7, lot 7, submitting the affidavit of interpretation as well as the proof of mailings to the secretary. And received prepared by Remington Vernick by Mr. Gallup. Thank you very much, sir. This property is located in the R6 zone. We are here simply looking for a waiver of the site plan requirement. Application that some of you might be familiar with that originated some time ago in 2017. Time the board had authorized the approvals for variance and also temporarily waived the site plan approval pending an application and approval from the Pinelands Commission. It's pointed out in Mr. McGowan's report. And I think he aptly captured what the situation was there, that there was during the design process, it was determined that the paving in the parking lot area would be technically infeasible. It also refers to the soil conditions cannot support compliant stormwater management system on the site without at a minimum significant complications and expense. So today, our application is simply to waive the site plan requirements because there's been no change on the property over the past 5 years since they acquired ownership. Elaine Folks, who is the provider of the corporation, and she's prepared to give testimony. Site plan has, at least an existing conditions plan has been submitted by from Duran. You have that in your packet. And I have a full copy, but I don't see a board that I could pin it to, but perhaps within the packet. You can plan. So with that, I guess I would call Mrs. and, testimony. We do not have an engineer here to testify. This box would be providing a testimony with a certified report, this plan prepared by Duran speaks for itself.
Ma'am, would you raise your right hand, please? You swear that all the testimony you offer this evening will be the truth?
Yes.
You can put your hand down, and would you please slowly state your first name and say and spell your last? Common spelling?
Yes,
Okay.
common spell. ELAINE, Hawks, HAWKES.
And I think Mr. Friedman said you're the proprietor. What is your legal title of is it a corporation or an LLC?
It's LLC,
And what is your role?
CEO.
CEO. Okay, thank you.
So it's what, when was the spread the gospel, what's the board discussion concerning the origination of that thing?
Spread the gospel in 2009. That's when we spread the gospel started.
And what does spread the gospel do?
Spread the Gospel is a nonprofit, community-based gospel radio station and organization.
There come a time in 2017 that you acquired property in Carver City,
Yes,
the site in question.
yes.
And what was your purpose for acquiring that property?
To further spread the gospel by way of giving, we have events at the hall as well as community, offering it to the community. And when we're not using it for our personal use, we also made it available for the public to use it for events. But we have we have different events there.
I understand that you also have a radio station.
We do spread the gospel, does business as Gospel 88.7, WEHA.
And how long have you reached that?
2009 is when we started the radio station, and then 2017.
And what part of the radio station do you perform at?
We don't do any business of the radio station at all.
And you mentioned that you do church activities at the hall.
Yes, we do our own events. We have in our community, and we have community events there. We also offer it. I serve on the Workforce Development Board. We've had meetings there. We've offered it to the Fellowship of Churches. We've offered it to different churches, pastors, as well as our community events and activities that we have. We have them all at the hall.
Did they participate, those people participate at the hall?
Yes.
Now, after acquiring the property in 2017, did you make any structural changes to the building, either inside or outside?
Only outside, we did parking ramp, handicap ramp.
Yes.
We did a 2 slabs for the handicap parking. And I think we painted and stuff like that.
Okay, that was one of the conditions that the board had to do.
The condition was the handicap ramp and the handicap parking spaces.
And those two improvements to the outside of the building, were any other improvements done?
We painted, that was been recent within the last year or so.
Okay. We discussed the parking situation, about the potential of parking, or at least the concept that you may want to do that in the future. Have those plans now been abandoned?
They have,
So the type of parking there is a gravel parking lot?
yes,
Is that the circumstances when you bought the building?
yes,
It was a gravel parking lot?
yes.
Okay. Board, I will just open up for the board if they have any questions of this witness. Essentially, our presentation speaks for itself in the documents that we've submitted, that there's been no change to the land, to the site, no other improvements done, and that's the basis why we're seeking this.
You would, Ryan, do you want to weigh in at this time before any questions or?
You want to ask questions first?
Any questions from the board at this time?
How many of these, out of these 8 requirements have been met to date?
4 of them were sort of events, I'll call them, numbers 5, 6, 7, and 8. 5, 7, and 8 were satisfied. 6 is what they're here requesting waiver for. The other conditions were all sort of ongoing, that would apply, in perpetuity.
The 8 AM to 11 PM, it was hardly ever followed with events that were posted there. So I don't know that they've been a very good steward to the community with the events that have taken place past these hours with the noise. There's no control of the clientele that come in there as far as where they park, how they park, and everything else. I don't. I don't know. I would like to hear how they're going to prevent the problems they've had in the past as they're located in a residential neighborhood.
So why don't I go through the application as it sits, the requirements that we have, and then we'll sort of go back to the applicant with, have them address, directly address those questions. So the application that was submitted was for the waiver of the submission of the site plan and the paving of the parking lot. Rules require that they submit an application with Pinelands and then come back to the board with a site plan that would include the paving of the parking lot. The process to go through the design was a lot more drawn out than I think we envisioned it to be. But ultimately, their engineer, after doing some soil testing and some design work on the site, kind of determined that locating stormwater management facilities on that site is just not viable. There's like a 5-foot thick clay layer from 5 feet down to 10 feet down. So getting any kind of infiltration facility to work on that site, which is what would be required to meet the current stormwater management rules, is, if not impossible, very close to being impossible. So that's sort of why they're here, is to come back and request, to just waive the requirement for the parking lot and submit that site plan, because they have those technical feasibility issues, as I told them. Thomas, as you sort of got to on the second page of the report, we did list all of the conditions of the prior approval, which there were 8. The first 4 had nothing to do with this. Like I said, the other 3 were satisfied. Obviously, we have some information that leads us to believe that the other requirements weren't met, but I think we want to ask those questions directly to the applicant. But I'll highlight that this application is very limited in scope. It is only for relief from that one condition. I spoke to the applicant's attorney earlier today about the fact that I'd be highlighting that there were other conditions and that we would ask the applicant to reaffirm that they still exist and that they would be adhered to. But they're sort of beyond the scope of the limited request that they're making. So I think you should have that discussion and ask those questions and highlight not only the conditions, but some of the things from the finding of fact that are not enumerated in my letter because they weren't specifically conditions. But from item 4 in the findings of facts of the approval resolution from October 2017. Yeah, October 17th, 2017. It said that the use would be by invite only, liquor would not be served in the site. If the applicant wishes to serve liquor on the site, whether through an on-site purchase or their own, applicant will need to apply for and obtain a valid liquor license. We discussed that at the hearing from what I recall. We didn't include that because that's just the law. That's something that they're required to do if there's alcohol served on site. So we didn't specifically include that as a condition. Another was the applicant testified that someone from the organization would be present at all events, and the applicant will act as their own security and maintenance, and is ensuring that the surrounding neighborhood is not negatively impacted in any way. So I think it's certainly within the board's purview to ask questions about, whether all of that is being adhered to. But I don't want to cloud the experience that has been had and the anecdotal information that we have about what has happened to the site with what is specifically included in this application. Does that make sense?
Sure. What was the date of the filing to Pinelands?
The original submission of Pinelands Commission.
Sure.
I think the original application submission actually did meet the 6-month deadline, but there wasn't sufficient information to actually, there's no way it would have been approved. There wasn't sufficient information in the original application to get an approval from the commission. So they went back and forth with their engineer over the span of several years, doing some site layout, going back, doing some borings, several iterations, several submissions to the commission. So like I said, it was a much more protracted process than was sort of outlined in the
So
resolution.
when was the complete filing submitted?
I think the original application was submitted within the 6-month deadline, but
What was
again,
the
there wasn't
complete-
sufficient.
What
I
was the
don't know
complete
that,
one?
I don't know that the Pylons ever deemed the application fully complete.
Okay.
So, but I'm not privy to all of the Pylons correspondence.
Question. You say there's a 5-foot layer of clay there.
Yes.
We've had a lot of experience with clay in A Carver City. And the high school, the middle school, when I was working at HERS, we dealt with it there. I had it in my backyard drilling a well. And there is nowhere that I know of is 5 feet. Did you have a chance to review the soil samples that came up?
So I reviewed the soil logs and I spoke to their engineer. And the way they described it was like dense, massive white clay. And it's
There's clay there,
consistent.
but 5 feet is, I think, a little exaggeration.
I mean, I trust me, we typically defer to the soil logs because it's, professionals like ourselves who are putting them together. So I wasn't there to witness the test pit, but I assume.
Is that information we can get?
I mean, we can request additional information on the test pit, sir. But I mean, I'll look back. I don't remember who did them off the top of my head, but I
So,
remember somebody at Thorne Engineers or a sub-consultant they.
Joe, if I could, let's back up to the application. So as I remember, and correct me if I'm wrong, Ms. Hawks, we only followed through with the completion of the parking lot because when you guys made the application, you wanted to pave the parking lot because you wanted the property to look nice. And at that time, not having any idea, that none of us did, that it would be virtually impossible to try to pave that parking lot because of the requirements of the DEP drainage. There's just not enough room and it can't be stored underground. So I don't think we imposed the parking lot on you, but because you offered to do it and it became part of the application, it just became necessary for us to follow through the motions to, approve or disapprove it. So in a roundabout way, that's why we're here tonight. I mean, at least that's the way that I understand it. Is that
I think it's
accurate, Ryan?
Would that be the situation? There's no requirement imposed to pave the parking lot, but rather it was something that, which your husband testified, that it was your intention that sometime in the future, we would like to do that. And in fact, you made the effort, and lo and behold, after the effort was made, you determined it was either just not feasible from an engineering standpoint, nor from a financial standpoint.
So there's no
was no-
Pinelands or any requirement to pave.
Yeah, there was no ordinance requirement, there was no technical requirement that we need to satisfy. I mean, I personally was not at the hearing, but from what I recall leading up to it, that was, and coming out of it.
Well, I wasn't here when that was done, but everything that I've heard since it was done was that was what was the big problem. That you had agreed to pave it and then that wasn't happening. And that was the big contention. So. Well, it was holding up the certificate of occupancy. Is that right?
Yeah, that was the condition that needed to be satisfied before the final CO could be issued. So that's what became the obstacle. It was incorporated in the resolution, not to meet any technical requirement, just because that's what was offered and that's what we incorporated in the approval resolution. And then without waiving that requirement, it needed to be satisfied or they had to continue to have TCO. So that's kind of how we got it.
Even
Is
though
that
I
why
said
the TCO was pulled or removed?
That's my understanding, yeah, because it was continually removed or continually, was refreshed or updated every 6 months or 3 months, whatever the requirement was. And finally, I think it was just too much time had passed, so we said, you're not making, enough progress. It was supposed to be 6 months. We sort of envisioned you back in through this process in a year and a half, and it's been 6 years, 7 years, whatever it was.
Ryan, I have a question. This is, I guess, goes to the history of the site itself. Before they took ownership of the site, before they ever came to the board, I'm assuming the site was used by someone prior to that.
It was the Knights of Columbus.
Knights of Columbus. I assume they had events and they used the lot
Yes,
unpaved in its current condition.
correct. I think the board had a level of comfort that they could move forward and utilize the facility in its current condition without a paved parking lot. We understood that it would be months or a year to get an approval from the Finance Commission and be able to pave the parking lot. So I think the board's intention at the time was really to say, okay, you can start to use it now, but you just got to keep moving forward on this path to get your parking lot paved. We don't want to take a year away from you waiting to get the parking lot paved, but we want to see you pave it. So get started now and then, start moving through that process.
My second point is that when we issued a TCO, I assume that was because they were substantially compliant with what the board wanted and what our ordinances were.
There was a requirement, a specific condition of approval that required the applicant to complete the required ADA handicap parking space improvements prior to the board issuing a recommendation to the State Harbor City for the issuance of a temporary space permit. So there was something that we wanted to see before we would allow that TCO. And that was ADA compliant parking stalls and ADA compliant ramp to the building.
And
Those were installed.
items.
Yeah, they pulled a building permit for those in December of 2017. They got their approval memorialized in October. So within 2 months, they got their building permit, built that ADA parking pad and built the ramp up, satisfy their requirement, got their TCO.
So is it fair to say that at some point, they were substantially compliant, at least at the time when they received TCO? One condition that is a condition that was present at the time that they were going to work on, they had made some assurances to the board they were going to work on. However, for the majority of everything else, they were substantially compliant.
Yeah.
And they remain substantially compliant.
Yeah, and they operated under TCO for 6-ish years. So
How long can, so the question, how long can someone operate under a TCO?
I don't know that there's actual guidance on that.
Is there any limit as far as renewals?
I don't believe so. In fact, I think the community school operated under TCO for like 15 years. Or something.
As long as the city would grant an extension.
Yeah, I believe there's a limit on the
Agree with the synopsis that's been given here. It was really an accommodation of the board accommodating the applicant that, we'll give you the TCO, and the TCO was obviously after an inspection to show that there's no health, safety, or welfare, the health, safety issues to occupants of the building. And they operated during that 5-year period. And we talked about not only the complications in the application itself, but we also have to do a pandemic in between, and state was not as responsive, and just engineering wasn't as responsive, and maybe my client bear some of that responsibility as to why this thing took so long. But the condition of the board was take care of the handicap aspect, we'll issue a temporary C of O, and when you get your approvals, come back before us and get the final approvals. So we've abandoned that effort now, and now we're looking to finalize those approvals. And I also add that the map, or at least the plan that was presented to you concerning the existing conditions, for all intents and purposes, is a site plan. I'm not sure what else a person would really do, or an engineer would reflect on those plans other than what's there. And I might add that the plans might reflect a storage building that has since been removed. There was a temporary storage building that was being utilized, and that is no longer on the property as well. So we're looking to have a waiver of the site plan approvals, so that we can go and apply for a permanent CO and get back in operation, because the city has shut us down for the last 5 months.
Any
No, I would like to point out though, just for your, just so you know, that the city has also amended, well, is attempting to amend the noise ordinance. So the times on this may be a little bit different, just for your awareness. It hasn't been passed yet, but it's been introduced. It's ordinance number 2 for 2024, amending chapter 189 of the noise code of Egg Harbor City. So just as an informational purpose to maybe amend this, what we have in Ryan's report is restricted hours during the weekdays, and this has nothing to do with your place at all. Just information so you know it's going to be changed. Shall be amended to 10 p.m. to 8 a.m. any day except Friday and Saturday. That's 189-1. And then restricted hours during weekends. That would be Friday and Saturday. 12 a.m. to 8 a.m. So I don't see where it says Sunday here. Well, Sunday would be during, they, I think, wanted to consider that during the week. Because Monday is I can give you this if you want the copy of it.
If I may.
Like I said, it hasn't passed yet. It was just introduced at
but
the
not
last
passed.
meeting.
Of course, whatever the township ordinances are, contrary to what the program will write, I think township ordinances.
Okay.
2 a.m.
I don't see that much difference, but maybe,
This is the
I
original
think Sunday would
source.
probably be the most different, I'm guessing.
Anyone else from the board?
Yeah, I have a couple questions. As far as some of these other concerns that Ryan went over, the application or applicant testified somebody from their organization will be present at all events and act as their own security. I think that needs to happen with the history of the different events that's happened there. There've been multiple. There was a murder, there was a shooting, I did an open request on this last year. There was one murder since 1/2018 to 6/27/23. The police responded there for 1 murder, homicide, 1 shooting, 4 suspicious activity, 19 noise complaints, 3 MVAs, 7 crime prevention activities, 1 unwanted individual, and 59 property checks. I think something needs to be done along those lines to keep that neighborhood safe, first and foremost, and then be a good neighbor to the rest of the neighbors there. I know some of the police reports, if you read them, they did start noting, I guess, originally they may not have known that was in there, that they had to have somebody there from the building. After, I think, the shooting, then the police department did start noting that in their police reports, that there was nobody present.
I know that and my client to testify as to her son is a neighbor of the building, lives right next door. And if you want to hear from him as to what kind of property checks he does.
Well, no, it just says that, and someone from their organization will be present at all events, and that the applicant will act as their own security. I mean, I think living next door is not the same as being in the building while something's going on. If there's 59 noise complaints, somebody from the building should be responsible to know that, hey, we have to turn this, whatever the noise is, whether it's people yelling, it's music.
We don't disagree that those things need to be approved.
But they weren't.
Well, the interesting thing about it is that nobody from, whether it's the city or the police department or a code enforcement officer has ever brought these things to my client's attention or cited her for any violation. We're not here to dispute.
Your client has no idea that there was a shooting?
No.
I mean, the
that's not
very
what it
next
says.
day, they were back.
Sure.
All right, go ahead.
Okay, number 1, and I think everybody already knows this, but it's so crucial that we don't speak over each other because we're making a recording, minutes are gonna have to be drafted, and we all need to hear each other. And while I've got the floor, I'm gonna try to put a fine point on what we're here for, if you don't mind. And I certainly don't want to step on anyone's toes. And everybody here knows that this is my first night here. I'm not intimately acquainted with all the facts. I only know everything that I've read and Rachel's read and we've talked about and said, how are we going to handle this? I have to admit that I'm quite pleased that it hadn't started getting a little heated before now. So good job, everybody, so far. But let me explain what our job here is tonight, so we can do it both for the city's benefit and the applicant's benefit, because you need to serve both. You need to serve the community and you need to provide a certain level of customer service to the applicant. We know back in 2017, there was a resolution approving certain things with certain conditions. If a question of noise, for example, let me keep it easy, was a question that the whole city was in an uproar about, and the city is already changing their laws. So part of our motion tonight, whether it's to approve or deny, let's say approval, the condition, one of the conditions, number 4, that says the operations are limited to Friday and Saturday until 2 a.m. We're going to put in the resolution that there's an awareness of the applicant that their new noise ordinance now is going to curtail noise to Friday and Saturday was 12 a.m. to 8 a.m. So we'll note that in the resolution, for better or worse. If the applicant breaks those rules, that's code enforcement. That's not planning board. What is planning board's authority tonight? The applicant is coming back, as you knew the applicant would, but the applicant is coming back and asking for something different than you thought it would. What is reasonably related to the relief being requested? And I'm so sorry, my back's to you guys. I don't want to keep it. So if we look at Ryan's report, let's go to page 2. Ryan has done a really good job of going through things that the prior approval from 27 was based on. Ryan's already told us that 7, 8, and 8 have been complied with, so that's done. We're talking about 6. So now we've got to look at 1 through 5. Based on what the applicant is requesting, which is relief from having to pave that parking lot. That's all there is. Is that reasonable? Mr. Timbers asked a very good question. What was the prior use? And is the current applicant in substantial compliance? If the use that's been going on since 2017 is about what the board in 2017 expected, you have to decide whether or not paving that parking lot is now reasonable or not. If we find out that back in the day when Knights of Columbus were in, 5 gentlemen a month came to the building, sat around playing canasta and left, okay, a gravel parking lot was sufficient. And this applicant, I wasn't here, we don't know what the applicant, I don't know what the applicant said in 2017, but for whatever reason, they offered to pave the parking lot. Is the use, are they now having 1,500 men come a night to play canasta? The gravel parking lot wouldn't handle that type of traffic. So you, as a board, a planning board, would have the right to talk to the applicant and talk to your engineer about what engineering problems would not paving the parking lot pose. If the applicant in condition number 3, if somehow not having live broadcasts at the station, if now you know they are, and the traffic generated by that impacts the condition of the parking lot and the standards that you need to uphold, yeah, we need to talk about that. The unfortunate events that have occurred on the site, unless they're reasonably related to paving a parking lot, that's code enforcement, not planning board.
the planning board has a very limited jurisdiction. So your questions have to be related to planning. So the questions are good ones, but they need to be related to what conditions you might be changing, enhancing, deleting. So that's what we need to focus on. And I know I went on a little longer than I probably should have, but if you have questions about that legal standard, happy to review them. I hope I haven't confused the situation.
I do have a question.
I'm confused.
Okay.
So I'm not allowed to ask that question?
Oh, you absolutely are allowed to ask any question.
Okay.
Um,
Any question about anything to
absolutely,
do with that building?
absolutely.
Okay.
Because we can explore what impact past events have had on the use of the property, because your job is to make sure that the use of the property complies with Egg Harbor City's and New Jersey's planning and zoning laws. But we have to remember the scope of the application. The scope of the application tonight is this young lady is asking to no longer have to pave a parking lot that she offered to pave in 2017.
I think it's critical to point out that there was an offer to pay it. It was an intention. It was not a condition that was imposed by the school.
Thanks, Mark.
Okay, so Ryan read paragraph, and you said that the building and its occupants cannot impede the rest of the neighborhood. How did you read that, Ryan?
So was it from the findings of fact of the applicant testified someone from the organization would be present at all
Where you
events, that portion?
Where are you reading from?
That's the prior resolution in 2017.
Read it again.
Sorry. The applicant testified that someone from their organization will be present at all events and that applicant will act as their own security and maintenance in ensuring that the surrounding neighborhood is not negatively impacted in any way.
Negatively. That's what I would do. Okay.
So I think to Carol's point, and the way that I tried to frame the review letter is that we can have a conversation with the applicant about these issues and ask them to reaffirm their commitment to the commitments that they made originally and that were incorporated in the resolution. That those don't have direct bearing on whether they need to pay the park. I think that's Carol's point. Is they're two separate things. While they're here, we could definitely
While they're
talk
here,
to
I
them
can ask the
and
question.
remind them that there are other conditions that need to be adhered to.
Right.
But it's not our job to enforce their.
No,
adherence to
no,
those
I'm just asking questions.
Yeah.
Someone else want a question?
Just
Well,
as,
I wasn't done.
just as.
What I was trying to get at is, you had said that your son lives right next door.
Yes, sir.
Okay, your son lives right next door. The police department was called. And you're supposed to supply your own security. And you were not informed. I asked you if you were informed about the shooting. And your lawyer said that you were not informed about that. So with you saying that, I have to wonder in my mind, if her son is right next door, there mustn't have been any security in the building when the shooting happened, or outside of the building when the shooting happened. That's what I was getting at. So the issue is the security is what I'm getting at.
Understood. My client is here. First of all, as I understand what had occurred there is that a person who's not part of the event that was ongoing had come from out of state with criminal intent and did this act, this criminal act. Nobody could be faulted for, somehow being able to predict.
I believe you're
and
misspeaking,
stop it.
sir. I believe you're misspeaking. To the facts of the event.
Okay. So the situation being that if there's a condition of the board which requires that security be on site at all times, my client is standing here before you tonight and prepared to affirm and acknowledge that's the case. And we're not here disputing what the conditions that were imposed by the board. We're here tonight simply to say that there has been no change in the site plan. That was the only remaining issue as far as this is concerned. If this board wants to refer something to its code enforcement officer to bring a notice of violation against my client, then due process will work its course and my client will defend or take her position as it pertains to that, and the chips will fall where they may.
Right, I understand that, but this is the only time that we have time and an opportunity to ask those questions. So that's why I'm asking those questions.
No objection to asking the question.
Just one point that I want to make is you mentioned that the intent was to pave the parking lot, right? It was not, you said it wasn't a condition of approval. However, in Mr. McGowan's report here, it does say the applicant reminded that there are numerous specific conditions of approval, and that is listed under that paragraph. So that's part of it, so there is a condition from the board, even though they volunteered to do it. It was a condition that the board imposed at the time that they were here the last.
Well, sure, that's why they're back to have that waiver.
Just a point, you're still asking for a waiver.
Hairs, and I did notice that Mr. McGowan's report, but obviously it's the resolution itself which dictates what the conditions are, and if you were to look at that, my interpretation of what the 2017 resolution, there's nowhere in it said that it says this is a condition of your approval, you must pave the parking lot. It said you must apply for it because they would like to have had it, they'd like to have been able to do it. Times proved otherwise.
I think to his point, the wording of the resolution is the only specific condition is that they apply to the Pinelands Commission within 30 days. Elsewhere in the findings of fact section, it discusses the requirement to make the parking. So it's not as quite as clean, but I think
It seems a little misleading here.
Well, I think it's clear that the intention was that.
Well, let me make sure the record's really clear though. We're not gonna debate what happened in the past. There was a plan submitted. The applicant suggested there was gonna be a paved parking lot. That's not a good or bad thing. Nobody needs to argue about that. It is. It happened. That was the status of the application at the time. Now the applicant, for legitimate reasons, is asking permission to withdraw that part of the proposed plan in 2017. We're getting off track here. We don't need to fight about who offered what. The application included an offer to pave. And think about a house being built. If somebody comes in and says, I want to build X, and then they want to change it, they're allowed to change it, but we're not going to fight about what the first application was. So there's no
So,
getting a little adversarial for no reason.
sorry, Carol, Ryan, there's no DEP reason or any Pinelands to say that it has to be paved, is there?
No, there's nothing that would require it to be paved.
Okay, so, I mean, they can continue to use it and it'll function like it has for the last 50 years.
I have a question. The reason it's not getting paved is because of,
In order to pave the lot, you would need to construct stormwater management infrastructure. In order to construct compliant stormwater management infrastructure, you need to have an infiltration component. I pulled up the soil logs. It describes it as white massive clay from 56 inches to 115 inches, which is approximately 5 feet thick, on one boring, and from 64 inches to 120 inches on the other. Same description, white massive clay. Juanita Dix is the geologist who did the soil boring. I have reviewed her work many, many times. She's been doing this for 30 plus years. So if that's what she says, I believe.
so it's not possible?
Yeah, so essentially it's not technically feasible. I mean, could you create like a groundwater injection well? I mean, you can solve any problem with money, but you might be, $250,000 to construct a stormwater management basin that's a little bigger than this table to make it work properly. So for all intents and purposes, that's what we, as engineers, would consider to be technically infeasible. It's just not viable.
Any other questions from board members?
I had a question.
I'm not sure, but there might be a conflict of interest, but I believe, Mr. and Mrs. Hawk, you purchased the property through my firm, Century 21 Frick Realtors, back in 2017. Did you use Dan Bodie from my office as your realtor? Century 21 Frick Realtors? Dan Bodie, so I didn't know if that was a conflict of interest, being that they purchased it and we handled the sale back in 2017 before I vote.
Right, so the question basically boils down to the fact that an employee of you earned your firm a commission, does that cause a conflict?
I thought, I
Right, no.
wasn't
it-
sure, but I just wanted to bring
Yeah,
it up.
it's a good question. This is not zoning, it's planning, and we got plenty of votes, so why not throw caution? Or let's be more cautious.
All right,
But thank you for bringing that up.
wasn't sure. You gave it a chance.
If we didn't have enough members, I would have aired on 2017 commission. So it's not like it's an ongoing business, but we have plenty of people to vote.
I do have a question though, but can I ask a question? Being that we couldn't pay.
No,
Oh, I
that's the
can't.
problem.
Now you got a conflict with yourself. I should ask the question first and then, okay.
Any other questions from board members?
Yeah, I have a couple of questions. So I know they're looking for a waiver on this, but does it not open up the door for other
I'm sorry.
terms that we could add?
Absolutely.
So we've opened up Pandora's box here both ways.
Well, just like I told Mr. Friedman, he didn't need to be so adversarial. I'm gonna say we don't need to say it that way. But yes, it's not Pandora's box because no, then that sense that you can willy-nilly.
No,
It's
but
not
we
regular.
could, we could now address some of these concerns that we didn't address in good faith in 2017 with some other terms as part of this application.
As long as they're reasonably related to the first application and the application tonight.
And our current use of the building.
Mhm.
So prior to, when Knights of Columbus had it, for probably many years prior, it was rarely used and very small crowds. The parking lot was normally sufficient. Since 2017, everything has overflowed into the street. I mean, most of the residents can't even park the car if they leave. If they leave to go to Wawa to get milk, they gotta park 2 blocks up the road. I don't know if it's clear what the building capacity is, but I think that should clearly be posted on the outside of the building. I think the orders, hours of operation needs to be clearly posted on the outside of the building. And I know there's a citywide ordinance for noise, but I think I would like to ask for a change to that as it applies to this property.
So why don't we break that down? First, I think you need to ask your engineer about what the parking for back in 2017, what the parking maximums were and what number, whether a parking lot is paved or not. There's only a certain number of spots. So why don't we deal with parking first?
Okay.
Sure. So the parking stalls, to my knowledge, have never been delineated. There's not like parking bumpers that would indicate X number of cars. So we don't really have a good history of how many cars could park in that lot.
Is that because that was anticipated to be addressed when they came back to address the parking lot?
Just speaking to the historical side of it, it operated as Knights of Columbus with, we don't know how many spaces. Because they're not limited. It's just essentially however many cars people could fit as they pulled it. So we don't know, really what the prior number was, and presumably it's operating in the same conditions, so it's called. I would imagine that if they paved the parking lot, the practical number of parking spaces would probably decrease because some of that parking area would have to be dedicated to stormwater management. And then once it's paved, it has to be striped and your stalls have to be certain widths and certain drive aisles.
I'm gonna interrupt. I think what Mr. Garth was asking, what the board anticipated in 2017, if I'm not mistaken, and please interrupt if I get anything wrong.
No problem.
Back in 2017, it was anticipated that the applicant within 6 months would go to Pinelands,
Yes,
get whatever approvals were needed, and then come back.
with a site plan showing a paved parking lot.
Right,
Correct.
okay.
Can we request a site plan without a paved parking lot? That shows parking, that shows parking bumpers, that this way we know how many cars can fit in the parking lot.
You could,
Shows
you
site
could
lighting.
reasonably request that the parking be delineated on the site, you know, in a matter of just it being drawn on the plan. I mean, what we have, an existing Digen's plan is a site plan where there are no changes, because it shows everything that's there. But if we wanted the number of stalls delineated and the locations where they were, I don't think that's an unreasonable request.
And I think the second part of Mr. Garth's question was, based on the square footage of the building, how much parking is required?
So I don't know what the occupancy limit is on the interior of the building. That comes from the building code official. I don't know what the posted number is. Presumably they have a number posted on the inside of the building. I think they would have to because of the use class that it is. Presumably, you know, if you have one car per person, certainly the number of occupants for that building is going to grossly exceed the amount of parking in that parking space or in that parking lot. It's just, without knowing the actual count inside, it's hard to know by how much.
And again, just so I can make sure whatever resolution we draft makes sense. If you propose a supermarket, I know that there's.
Yes, per square foot.
Exactly. Is there any rule in Egg Harbor City that would govern the number of parking spaces a building of this square footage?
Yeah, that would be
has to
required as built, constructed. Yes, the ordinance.
And
does.
how many spaces, do we know how many spaces
I
that is?
don't, we'd have to go back and do the calculation. I'm not even sure how many square feet.
Because these are the type of questions that would be asked if
Yeah.
they had gone to Pineland, right, exactly.
Yeah. Okay, well, there you go. So yeah, Tim has parking delineated as they applied as a church, one space for every 5 seats in the church auditorium. So I don't think that the way that the parking was evaluated originally is really reflective of how the facility is being used. You know, it would be gathering hall or something like that, which has a slightly different, obviously it's not for number of seats because you're not anticipating people sitting all the time. So, yeah, I don't, well, we can go back and figure it out, but I don't have that number.
So how do we answer this if we don't have the answers to the question?
Well, after the board's done asking questions of the applicant, then we're gonna have to open up the meeting to the public. When all the questions and statements have been offered and answered and repeated a couple times, somebody will make a motion and, I'm sorry.
In the Pinelands application, wouldn't that say the occupancy? of the building?
Okay, I'm sorry, then let me finish what I was saying. Someone will make a motion to approve or deny, and if there's a motion to approve, it will be with conditions. I can help you guys frame that, and perhaps one of the conditions would be, and even though it's a gravel parking lot, there will be bumpers, there's $50 bumpers that delineate spaces, and the parking cannot exceed X, you know, whatever the ordinance says.
Okay, so we also talked about, you had mentioned, you have to consider what it was when they purchased it, what the use and the impact on the community when they purchased it. It's pretty small, as you said, there's not many people showing up to play whatever game you mentioned.
Canasta, my grandmother played it.
Never heard of it. So now we can take that in consideration. Is that a true statement? Based on its known use for the last 5 years?
Yes, but keeping in mind with the parking lot construction, it's a very narrow engineering issue. Does the city have an ordinance requiring that it be paved? I think I've heard no. Does Pinelands or any other government agency require that parking lot to be paved? The answer is no. So unless there's some indication that and I think my number was 1,500 men a night coming to play canasta, which means they're taking that gravel parking lot, and there's so much traffic, they're making divots and it's sinking in places, and there's really bad flooding during storms. Conditions with regard to, or considerations, I should say, with regard to whether or not you're going to grant the requested waiver from what they said they were going to do,
you gotta be careful about that.
Okay.
You can't say you gotta pave it because you think that that might, not you, but anyone, thinks that that might deter the problems that the city may
Okay.
have
So we just need to
experienced.
address the actual other problems and not the parking.
Well, paving and parking are two different things. I think you bring up a very legitimate point about parking. But the paving might be a different issue for the reasons, engineering reasons that
Nope, I get
Brian
it.
has.
I get it.
And to your point, the number, the inadequacy of the parking lot as to the number of stalls isn't impacted by whether it's paved or not. So I think that while that's relevant to the application and how the facility functions, I don't know that it's relevant to the paving of the lot. Only so many cars are gonna fit in that lot, whether it's paved or not, and, excessive traffic in it, is gonna be governed by how many cars fit. Once it's full, people stop pulling into it. So there is a separate problem of overflow parking in the street, but whether the lot is paved or not, I don't think impacts that specific problem. Does that make sense? So I think Mike's idea of requesting that the stalls be delineated on the existing additions plan to reflect the number of stalls that we anticipate having. And then having that discussion with the applicant as to whether the number of parking spaces is adequate for the events that they're hosting. I think that's a separate conversation, but it's.
So is your client still intending on renting this out to the public for weddings and parties and everything else, or is it going to be used strictly for church purposes? What is its future intent?
There's a commingling in that concept as far as whether it has a church-related party or gathering. So that's one part of the answer. The other part of the answer is, yes, I think that they intend upon continuing to have weddings there, have meetings there, and obviously they're going to have different amounts of people attending them. And we are not really, I guess, prepared with our engineer to start to address changes that this board might be considering based upon the history of this on making site plan, making modifications to your conditions when granting the prior approvals. So
Let me ask you something, Mark. Because I think a legitimate issue or question has been asked with regard to if the board envisioned that when you came back with plans for the paved parking lot and keeping in mind what the 2017 application was and the representations made, and I'm making up a crazy example for illustration purposes. You would agree that if the proposal was to put an Acme on the spot, we know how many people come in and out of an Acme, you gotta have a certain size parking lot. Are you comfortable going forward knowing that an issue with regard to the amount of people that might be coming to the site on any given night and the overflow parking, do you want to talk to your engineer about how many parking spaces are needed for that size building and how many you can fit in this new gravel proposed
my
lot?
client's been put deprived of revenue from that property for the last 5 months. So
I'm only making sure you have an opportunity to put everything on the record you want.
Well, I haven't heard any, it would require, quite frankly, from our point of view, that if you want to make modifications to the conditions of the approvals that were granted 5 years ago, based upon the experience that you've had over the last 5 years, then you should be eliciting some factual testimony and proofs brought before this as to where is there a problem or there's not a problem. I do.
Mark, I'm not gonna argue with you about whose obligation it is to provide proofs. I was just offering, because I think the question was a legitimate one about how much parking do you have to provide? I asked our engineer. He said what he said, you said what you said, but
How do
the
we
answer's
answer
no.
that?
Okay, no, the answer's no.
The answer is,
Okay.
I think we have sufficient parking, but that's our point of view.
Okay, very good.
I have a question. You just mentioned that they have been deprived of 5 months of revenue. Why did it take 5 years to come up with the idea that it was too expensive to pave the parking lot?
because the,
And I know you said
latest
that-
response from Pinelands was rendered in the fall of 2023.
So it took Pinelands 5 years to respond back?
The facts on the facts on the record already are earlier that Ryan already offered that the, let's see. After the 17 approval, an application was provided to Pinelands within the 6-month period of time, but it was deficient. It was not complete and was never deemed complete by Pinelands.
Yeah, so they didn't do their paperwork. So it's not Pineland's fault then. They just deemed it incomplete. So I mean, that's like me filling out a job application and forgetting to put my name on. I mean, it's my own fault.
This is a nonprofit organization that does not, that has a limitation on how much funds that it's capable of spending on building a parking lot that they hope to be able to construct. And lo and behold, as Pinelands says, we need more studies done, we need more soil analysis done. They go back to their engineer says, I require X amount of dollars to do those studies. Those things start to total up and eventually they get let dry of the ability to raise the money to pay for the application, plus the practicalities that they're coming to realize, their engineers telling them that it's impractical to put it on that property. So they've abandoned that effort. You want to say that that's their fault and therefore make some sort of appropriate action against them? I guess you can try to do that. I think that would be extremely unfair, unwise. We came here with an application pursuant to your statute that talks about 170-27B. The land use board, on acting on an application site plan approval, has the power to grant waivers when, under this chapter, it's impractical, unnecessary, or will exact an undue hardship upon the developer because of particular conditions pertaining to the land in question. As your engineers testify, the land in question will not contain a paved parking lot and all the stormwater management infrastructure that has to go with it. So yes, there's a undue hardship being exacted on my client for them to fulfill their dream of basically being able to put a paved parking lot there. I don't think the issue really at this juncture is a paved parking lot.
I don't think that's what he's saying, Mark. You got paragraph 8 of the 2017 resolution. I'm going to read it into the record because I really am trying to focus this so we can move on to the next question. The public offer testimony following comments, if any. Kenyatta Covington, who lives across the street from the site along St. Louis Avenue, spoke in favor of the proposed use. Specifically, she stated that she has attended a number of events on the site over the years, and she'd much rather see the building in use than vacant with for sale signs. Further, she was initially concerned about rowdiness and parking, but after hearing who is purchasing the building, being applicant, she feels everything will be kept under control. Finally, she added that guests of the site should be instructed to park in the parking lot. Manny Ortiz echoed Ms. Covington's remarks regarding parking. So let's move away from the paving issue. Let's move away from that.
If there's overflow parking that's going on the street that's interrupting the neighbors, then the city has resources to either ban parking or to restrict this property owner from having more than X amount of people attending with vehicles.
I will respectfully disagree and go back to my Acme example. You can't come in as an applicant and say, we're going to have 10 people a night and therefore a parking lot that holds 30 is more than adequate. And then the board members are just asking, based on the experience from your client's usage of the building from 2017 through now, if there is a parking issue, do we not have an obligation just to revisit it? It's not about the paving. So I think we beat that.
That's your prerogative to do so. I'm just saying tonight would not be the appropriate time to do it. Because.
Mark, I'm gonna disagree. We need to move on to another question. The board has a right to ask questions about the property's usage. I mean, they do. They do.
understand that, but to make changes without providing my client an opportunity to be able to offer contrary testimony to what's been heard.
This gentleman is not testifying. No one's testified yet except your client.
Right.
They're asking about the adequacy of the parking lot, even if it's not gonna be paved.
I'll make
This-
it simple. We believe that it's adequate.
Okay, great. And that's what's on the record. So why don't we
I have
move
a
on to another
question.
question?
John, wait, hold on just a minute. Okay. John, are you done?
Well, at some point, I'd like to make some recommendations to some use changes, but I don't know what the proper time is for that.
Let Mr. Keener ask his question and then we should open it up to the public.
So my question is to Ms. Hawks. If I went to rent the building, if I wanted to rent it for a function, is there a requirement that you would give me to how many people could go into the building?
Yes, as per the Egg Harbor City Fire Marshal, there's a tag on the door, so in the main hall, 200 people.
Okay.
In the bar area, I believe it's 50, so those are the guidelines that we follow when we walk through with people, we tell them, this is how many people you're allowed to have, you can't go over that.
Now, how do you monitor that when I come in with my 300 people? Is there a way that you monitor that and control it if 300 people come instead of 200?
Seating for the 200, I don't have enough tables and chairs to fit 300 people. I have
Okay.
enough for up to 200, and most of the time when people set up, we're there for the beginning part of the setup, to let them know here are the tables, here are the chairs. Things of that nature.
But there are people there that watch what's going on, as to their point before.
Not necessarily watch, but when we first turn the building over, we're usually there to let them know this is where this is where that is. Let them know how everything works, how to turn on the lights. This is the back door for parking lot. Here's the ramp if you have someone who needs to use the handicap. So we're there in the beginning part, just walk them through how, this is how you close at the end of the day, things of that nature.
My question is based on parking, because if you have 200 people, the parking lot and some spots on the street might be adequate. But if they over and supersede the requirement of how many people can be in the building, then that's probably what's causing the neighborhood problems. Just a statement.
I'm sorry, what is the capacity of the building?
She said 200.
200.
And 50 at the bar. Yeah, is it 200 plus 50 in the bar or 200 total?
No, it's 200 in the hall area, and then it is 50. But like most parties, when I'm gonna host a party on my application, it asks how many people are attending. So usually I know what the entire party is gonna consist of.
So 250. 250.
250, yeah. So I did my math with 200, and that means that we would need at least 40 parking spots there at 5 people per car. I drive a Corvette, so I can only fit 2. So that would mean that, you don't have a lot of, I would need my own parking space for 2 rather than 5. Do we have the space there for 40 cars?
No, I actually just ran the numbers. Your ballpark capacity is about 30. So you have about 8.3 people per approximate parking space.
That's without using the street.
Correct, just within the parking lot, yes. That's just based on the full length dimension of the lot. The lot's 150 feet deep, a standard parking space is 9 feet wide. So that works out to 16.3. You obviously can't park right on the sidewalk or right in the very back on the alley.
Sometimes they do.
Well, I'm sure, because it only fits 30 and there's
Mhm.
200 people. But
And it's not delineated, so.
right, but that's what I said approximately.
And to your point before, if it was paved, it would be less than.
Yeah, because you would lose some of the site to storm management. So paving a lot would actually make the parking.
How about the other side of the building? On the side between the house
Empty
and the
lot.
building? Yeah, it's an empty lot. Could that be used for parking?
Grassy area.
Yes, yes.
not without filling it in.
Here is the grassy area that we use to supplement.
But I
Now
know
we're
we're
getting
getting
the site
on
plan.
you guys met the different aspects, so I wouldn't want to commit it to parking.
And
But
plus,
but if people want to use it, I don't tell them, do not.
well, I'm not talking from an engineering point of view, that's Ryan, but from a legal point of view, now we're talking about site plan. You know, the applicant didn't come here
Mhm.
asking to
Mhm.
amend his site plan, or site
Submit a
plan.
new application.
Exactly, they're asking that this board, based on the old approval, grant a waiver of site plan. So if this board thinks that the parking situation is adequate and working well, you'll take that into consideration. If not, you'll take that into consideration.
Last
It's a
question,
follow-up
Ken?
question, if I
Yeah.
may. If somebody was to put on the application that they're going to have 300 people attending the party, what would you,
Yeah,
what
that's
would
not
you,
allowed.
that's not allowed?
That's not allowed, I don't have enough with that.
Well, that's the only standard that we have to go by right now, is the fire department says the occupancy of the building. Oh, there's-
Any other board members?
I just have one more question. So I understand very well that we are dealing with the parking. And I understand very well that it cannot be done according to all of the discussions that we've had tonight. So if they are granted the variance that they want, or the motion that they are asking for, does that mean that they will get a CO and then business as usual? That's my question. Yes or no?
The code officer will only know that the planning board said they don't have to pave the parking lot.
Right. So if that is granted, then they can continue with business as usual.
That's up to the code
Okay.
officer. I know nothing about
All
any
right,
other
thank you.
issues that might be in that office.
If I may add, if the conditions, the existing conditions are violated, the code enforcement officer can cite them for violating your conditions. So that's within their power to do. So
The code enforcement officer can certainly do their job.
they enforce the provisions and the conditions passed by your land use board.
Of course,
And the property maintenance code.
of course,
So that's all. Code enforcement.
right.
Glad said, we answered your question.
That's it.
And before I go to the public, is there anyone else from the board at this time? So ladies and gentlemen, I'd like to open this application up for public comment. Is there anyone from the public that would wish to speak on this application? Yes, sir. Sure, you could speak from your seat if you wanted to, just, that's up to you.
No, please not.
No, okay.
No, we need
Okay.
close to microphones and,
Well, I don't want to be redundant.
no, you have, no, sir, you have to come up, I'm sorry.
You'll need to be sworn in.
You have to
sir.
come in, you have to get sworn in and you need to state your name. So raise your right hand. Do you swear that everything you offer tonight will be the truth?
Yes,
Okay, you can put your hand down and what is your name?
my name is William Hawks,
And where do you reside?
16 Tower Avenue, Egg Harbor Township, New Jersey.
Great, thank you.
Okay. All right. I don't want to be redundant because my wife basically offered the testimony and answered the question that didn't want to be answered. I just reiterate the fact that we're only talking about this parking lot because when we moved into the area and assumed the property, we sincerely, with everything that we've always done down through the years in terms of our community involvement, our church, maybe had a deacon in church and all of that stuff like that. We just wanted to provide an extension to the work that we already do, that we've already been doing for many years. So we were able to acquire this home. In that spirit, when we came out here, I just wanted to say, okay, we want to be good neighbors. We want to have a nice place. As you see, in the few years that we've owned it, we didn't have to paint it, but we put a nice paint job on the building. You know, it's been a place where people have been able to come and, you know, and feel comfortable. And I said, you know, to further that, we would like to do a parking lot, the same as if I moved next door to one of you and I said, okay, I want to plant roses one day, and I want to do this, and I want to make it nice. That was the spirit, if you, many of few of you were here. That's the spirit I'm offering this parking lot in. I did not know, again, I'm trying not to be done, but I can't help it. I did not know that even on the application, they said, well, how much do you think that it would cost to do the parking lot? I've been around the block, I'm a deacon at my church, I, you know, business and all of that. So I said, you know, maybe $15,000, something like that. I didn't, you know, we spent the money to enlist Duran Engineering. They did what they were supposed to do. They came out there and did what they were supposed to do, you know, and it ended up being this great big thing. But we did our due diligence. I do want you to know that, because we would like to see it smoothed out, even though it's been a gravel parking lot since it's been built since 1955, I believe, or somewhere around there. And, you know, so nobody ever asked us when the only thing again that came up was that we had to do before we could even open the door was to put a handicap ramp there, which we did immediately. That was, you know, cost intensive, if you will, you know, because this is our first endeavor in something like this. But we did it because it was a requirement. The parking lot pads for the handicap, we did it. Again, to make it even more nicer, I'd like to see the parking lot paved. That was the spirit of all of this. And so now that we see that it's not cost effective, and it came up a couple of years, it took you 5 years. Yes, it took 5 years. We had a COVID in there. Every time my wife went to do the new temporary TCO, I believe it is every 3 months, every 3 or 4 months, every 90 days, she offered documentation of everything that the engineer told her or Pilings told her. So the fact that it dragged on, because anything that goes on a long time, you want to know why. We didn't just one day say, okay, this has been 5 years. She would take it to Donna, I believe, and it would actually say what the status was at that particular juncture. We have COVID in there. We don't have this, we don't have that, but it wasn't because we didn't do our due diligence. You know, we spent money that we didn't have for this engineer and all of that. You know, I don't want to speak derogatory of the engineer or anything. I don't want to go down that road, but we did our due diligence. So I want that kind of to be understood, as opposed to, because I've heard it a couple of times, well, why did it take 5 years? Because it took 5 years. It took 5 years. But that wasn't as a result of us dragging our feet or anything like that. We enlisted the engineer again. We enlisted the pilots again. We had a COVID. But we offered the documentation and everything every 3 months. 5 years in this coming, you called us out. It's been 5 years, shut your doors. It wasn't nothing like that. So I guess that's all I got to say.
Thank you, Mr. Hawks, but we continue to renew the TCOs because
yes,
we thought that we were going to make progress.
Yes.
But as a board and, you know, to put this application to rest and the CO and all that, it has to come to a head sooner or later.
I can
So
appreciate that.
that's why we're here now.
I can appreciate
To try and, you know,
Yes,
how long could we possibly continue to keep issuing TCOs?
No, I totally
So,
understand.
you know, we tore the scab off and now here we are and we're going to get
And
a result.
I'm glad we're here at this
Yeah.
point, because like I said, this couldn't go on forever. But, you know, I just kind of want you to have some insight, because you're residents as well. and you kind of want to know what's going on in your city, you know what I mean? But we came to, as earlier testimony here suggested, that she read back in 2017, we came to help enhance the city, you know what I mean? So after all of this, we still want to continue to be that good neighbor that we already started out to be. I heard some testimony saying that we had all these complaints and this and that, and the other and all of that. We haven't heard about it. We wasn't served with anything. I got 2 calls, you know, and I don't want to tell them too much, but I got 2 calls in 5 years saying something about noise. And they told me this, and I'm no expert on any of this, but they told me, they said, well, you get 3 or something like that, 3 or 4 within 6 months or something like that, then you could be issued a citation, something like that. We never been issued three complaints, never.
So, Mr. Hawks, let me ask you a question. So we appreciate that we're trying to improve the property, and, you know, I recognize that the building is in much better shape than it was. You folks have done a lot to it. So, you know, it's a small town and everybody knows one another. And as board members, now, we have limited powers here, okay, other than to sit and hear applications and try to make both sides happy. But we hear a lot of feedback from residents. And now, I can't offer this as testimony or whatever, because it's hearsay or whatever, but the big thing that's on people's mind is because of events that have occurred there, not the fault of your organization at all, or the people having the event. They're concerned now. You know, the parking is one thing. People come, you know, you can park on the public street. There's no reason that you can't do that. And it does in the neighborhood, but parties have been going on at this place for many, many years.
Sure.
But when there's firearm discharges and stuff like that going on, people are really concerned. Now, we're limited in that we really can't talk about all this stuff right here, but these are the things that our neighbors or whatever that are bringing us. Now, we haven't heard other members of the public speak now. I'm only telling you our perspective as board members, that we have to weigh all this. So, you know, we want it to be a safe neighborhood, and it seems to be a pretty well-run organization, but I think we need a little more reassurance on your part that you will make an effort to have someone on site while these events are taking place.
I don't think they need to make an effort. I think it's in here.
It's in the agreement. I understand that, and I know that it can be enforced by the code enforcement official, but it's not the same thing, because we don't have control over the code enforcement officer. And that's not Mr. Hawk's fault. But these are the things that are on people's mind.
Absolutely.
And, you know, they were all noticed, you know, to come if they had anything to say, and they're not going to differentiate between what they're feeling and what the purpose is for the board to be here tonight, as far as the parking lot and the paving of the parking lot. But this is what's on people's minds, and people are uncomfortable in their neighborhood when events are going on. Not because of noise and all that. I mean, in all fairness, I read the police activity, and there was calls for noise and all that, and there wasn't one time when whoever they spoke to didn't comply and turn the noise off.
Right.
So that happened. The unfortunate events that happened.
If there's somebody from the building there, that could get stopped before the neighborhood's disrupted.
Well, as we evolved into this thing, Mike, I get that. What the law enforcement nor code enforcement knew that was part of the resolution. That was part of the agreement that was supposed to do that. So now they know. And listen, we don't want to write citations and do all that kind of stuff there. It's a good use for the building as long as it's managed right. But the public and the neighbors, they need that assurance that, you know, we're gonna manage it better.
Well, only thing I can say again, and you're absolutely right. but we, if you will, we live there too. So we have a commonality, we have an interest.
Understood.
And that's why we made it our business to do improvements that we didn't have to do, and all of that other stuff. To your point, when that unfortunate incident happened, and I don't want to minimize it, it happened one time, and of course, one time is too many. Of course, it happened in our parking lot. It was at a repass. So again, to earlier testimony that I heard, it wasn't a wedding. It wasn't a party. It was a repast. Somebody was burying their loved one. Somebody came from out of town. So of course, that's like the least likely place that you would think anything like that would happen. And of course, not to try to split hairs or anything like that, but if it was a shooting maybe a month ago, right down the street. And then I think maybe a year ago, something was a shooting around the Wawa. So things happen. Things happen. And again, I'm as concerned about these things to the public as you are, because I live there too. I have an establishment there. We have an investment in Egg Harbor. So again, I'm not trying to be oblivious to the concerns of anybody here or anybody from the public or this and that and the other, but I do kind of just want to offer a little bit of insight of our thinking as well, because we live here too. When that happened, that unfortunate thing, the first thing I did is I reached out to you. And I won't, I don't have to like name names or anything like that, but I reached out. I said, what can we do? What can we do? What can we do? Do you need us to do this? Do you need us to? And of course, because, legalities and all of that, I was, said, we can't speak on it because blah, 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 blah. So what I'm saying is we've always wanted to be in compliance. We've always wanted to hear feedback, but we always wanted to be fair. We want to be as fair and as we want you to be as that give us the same considerations as well.
Mr. Chair, I'm just gonna offer this, and I'm sorry. This, all wonderful testimony, but really part of the application in support, we need to, and I don't know how much you guys stay in line with time limitations, but other members of the public who aren't part of the application do need an opportunity to speak.
Understood, but I would like Mr. Hall to be able to finish his. Yeah, thank you.
I'm sorry?
Like I said, I don't know.
Oh,
If you have-
if you want, you can stand too.
No, I was just saying.
Yeah.
Anything else?
Unless you have any more comments.
No.
Thank you. Okay, and anyone else from the public wish to speak on this application?
Mr. Chairman, good evening. Ernest Corsi, Atlantic City, New Jersey.
Hold on. You know the rules, Mr. Corsi. Carol Goloff at your disposal. Raise your right hand.
I just did.
I know, but I didn't swear you in.
You got it.
Do you swear that everything you offer tonight will be the truth?
Yes.
Now put your name and address on the record.
For the record, Ernest D. Corsi Senior, Atlantic City, New Jersey.
Nice to see you, sir.
It's always a pleasure. Ladies and gentlemen, ma'am, good evening to everyone. Listen, I come tonight in support of the applicant. Listen, I get it. In the business in Atlantic City, we understand how neighbors complain, stuff happens in the communities. When you have a business, a family business who's trying to make stuff happen in the communities, as Mr. Hawks has indicated, they've been around with the radio station, stuff they do in the communities. I thought it was very important for me to come tonight and support them. Why? It's because I've had the opportunity to use the hall as well. Again, for weddings, for repasts, for parties, etc. And so we found the place to be very clean, very nice, very hospitable. Yes, we can talk about the parking lot. The lot is what the lot is, right? The building is what the building is. And at the end of the day, there's always room for improvements, right? There's always opportunity to make changes, do things, see things differently. But at the end of the day, listen, I believe they're good neighbors. And I am sure that no matter what happens, at the end of the day, safety is number one priority to them, to you, to the city, and certainly to your residents, right? And so I get it. I'm down in Atlantic City. Y'all know everything happens. When it happens in Atlantic City, it happens everywhere, right? Good, bad, or indifferent. The fact of the matter is that people are trying to do stuff in the community to help people, right? People are not always fortunate to go to big hall to have whatever events they want to have, whether it's a sweet 16, again, whether it's your repast, whether it's your birthday. It's probably, and I can't speak for their pocket, I don't speak for nobody's pocket, but mine is empty. The fact of the matter is that, listen, you provide a service, you put it out there, when you close 5, 6 months, that's the impact on your pocket, right? And so whether it's a security issue, and I'm sure again, Mr. Hawks will take another look at that, and whatever decisions they need to make with the city to make sure it's safe. Because if they're safe, you're safe. If you're safe, they're safe. The community, it's all about being a partner in the community. And so what happens is you gotta be good neighbors. We're gonna agree to disagree on some issues, and at the end of the day, guess what? How do we make it better? And I come tonight, the ladies and gentlemen, ask you for your support. Listen, there's some rules and regulations they're gonna have to abide by. That probably wasn't not in effect when they bought the building. Good. You make changes, you move forward, and you live by the rules and the regulations. And there's a whole other ways that you can handle it. But I wasn't gonna say absolutely nothing. It's past my bedtime, but I could not leave here tonight without speaking on their behalf because I came with the intent to support them. I didn't know it was gonna be this long. The fact of the matter is, there's been a lot of discussion, a lot of good questions has been asked on both sides of the aisle. And so at the end of the day, we're the, minds come together and say, how do we make it work for everybody? And so tonight, ladies and gentlemen, I come again in support of this applicant, hoping and praying that you can see the same thing. Again, if changes need to be made, you make the changes. And again, I don't think they're going anywhere. They made an investment in the city of Egg Harbor. And at the end of the day, it's a family-owned business, and they've been known throughout the community. So again, I come tonight in support of this applicant and hope you would consider that application. Thank you so very much.
Thank you, Mr. Corson, for your comments. Okay, ma'am.
Sure. Raise your right hand. Do you swear that everything you offer tonight will be the truth?
Yes.
And put your hand down. What's your name?
Laura Ebert,
Laura, spell last name
EBERT,
and your address.
240 Chicago.
Thank you.
Just go ahead.
Yeah.
I live on the opposite side of the alleyway behind Beacon Hall. In terms of what was being discussed tonight, which is the parking pad situation, I don't have any problem with that. I don't really care. Like, it's not an issue for me. If they have, if they park on the grass or park on the gravel or anything. My main issue is that, like, less than 20 feet from where I live, there was a very, very, very tragic event. And I don't think it was appropriately handled in a way that would keep everybody in the community safe. My kids play in the backyard, and this is, I'm 41, I'm buying a house pretty late in my life. This is my first house. And I fully didn't expect to have, people parking within hearing distance of my house because they've been drinking too much in the parking lot. Just the back door getting open the entire time with the music and stuff like that. And I don't think that they're being bad neighbors. I think that with proper, I don't know if I can't think of a word right now, my brain is like completely numb, sorry. With proper precautions and proper security, that it can be a safe place for them to continue having their events. I have been in contact with Ms. Hawks before through text, and I have text her, hey, it's a little bit too noisy or the bass is too deep. So, and it's been turned down. I can attest to them complying with that. It's just, I feel like I've seen definitely more than 200 people there on occasion. And sometimes that's something that they can't personally control because, people just, hey, you can come with me and stuff like that and pop in. But like I said, the parking doesn't matter to me. I'm just concerned about the safety of my household, my children, my property. And as long as they're doing stuff to secure the property, to keep it safe, to keep their clientele safe that comes in there and has their events there, I'm cool. I'm very cool. I'm very non-confrontational. I just don't want it to become a place where, once the CO is signed off, that it becomes
you know, I can't think of anything right now, like my brain is completely done
It's
for the day,
okay.
sorry. Like Party Town USA back there at 2 o'clock in the morning, and for the record, I don't think it's been ever that late, but it has been definitely past 12 before, where the noise has been kind of excessive. The bass really affects me, because I have really bad sensitive hearing, so I'll have to put on like headphones at night, but it's just, if there's proper precautions being taken, I'm cool. If there's security and safety there, I'm good. But when there's a murder like 20 feet from my house, I'm not happy. I don't think anybody would be. I don't think anybody in this room would want that happening behind their house. And I do apologize for houses rambling and stuff, because again, it's late at night. I would like to go to bed, but that's all. Thank you.
Thank you for your comments, ma'am. Okay, yep, yes.
Hi, I'm Danielle Covington, CLG.
Hold on. Do you swear that everything you offer tonight will be the truth?
Yeah.
And now what was your name?
Kenyatta Covington.
Okay, I mentioned you earlier.
Yes.
You can put your hand down. Thanks.
All right, I just wanna share, some insight back from back then, everything.
And what town are you from?
From Carver City, I live on St. Louis.
Great. And I'm sorry about that. It's just for the record, we need to put that stuff on.
The parking situation, like the parking lot being paid, you know, that shouldn't be deterrent to have them operating. I'm just coming up here about the parking. Just think more so that people don't really realize that the parking lot is there, the people just come up to the street and just park. It's before they go around the corner to park, so our parking could be full, but the parking lot's still coming, or, you know, somewhere. But it's always been a parking issue for years, even when it was Columbus, and even when hers would come and have their party once a year, we don't have all the trucks there, so that has nothing changed, that's still the same thing. So, they maybe try to direct the people to say, down the street is parking on side streets, then because there's less houses on the side streets. Other than that, parking is okay. Hearing noise, it don't affect me, I'm across the street, don't affect me, I don't really hear it from my room, so only every now and then, here and there, nothing like major, but I don't live directly in front of them. And it's more so if somebody open the front door, come out, you kind of hear it a little more, and then it's not like constant. And with the shooting, I think that was, it was a funeral, so nobody would expect that to happen, and it would happen on the street of St. Louis where a person came out of town and the person came to the car and he shot him from the car and drove off, so, but the person kind of made his way to the parking lot. So, I don't think we could have avoided that. And, yeah, we all want some safety, as far as shooting, nobody, you know, that scared everybody. But, that day I was working, because I own the salon right there. So I was a little nervous. I did call and he was right on the scene. So I think, he handled that, got on the scene right away. So, just a few months ago, or a month ago, there was a shooting on Havana. Cops was out, cops was at my door looking, acting for our security camera for something that happened on Havana. So shootings is here in this city. So that's the whole city needs to get taken care of. So it's not just that one little part. There's a lot of stuff that's been happening in Carver City, period. I think it's just the time we're living in, and inflation's going up, everything's high, so it's hard to, everything's high now. So if you're gonna be closed for a lot of months, that's gonna be a hardship, and then we'll have another abandoned building sitting here for nothing. So, hopefully, they get back onto business and they can take from what they hear from today and maybe try to improve a little bit of the security or a little of the noise ordinance or whatever. And I think everything should be worked out good. Okay. That's all I have to say.
Thank you, ma'am.
Thank you. I come on up and get sworn. Do you swear that everything you offer tonight will be the truth?
Yeah.
And what is your name?
My name is Tanaya. That's actually my mother.
Very, spell Tanaya,
Tania.
and your last name?
Lanham, Lanham as in Mary.
And what town do you live in?
I live in Egg Harbor. I live right across the street.
Thank you.
I would say, as long as they've been operating there, I've never had an issue. I would like to say I honestly have more of an issue with the college kids on the corner of St. Louis. Yeah, their parking, glass bottles, like just looking at their property, it's just, they've been more of my issue, and I just wanted to say, I hope we're focusing more on that than just like the parking situation they have with their building and things like that. I have called a complaint with them, and I haven't really seen much of a change. And like I said, I live there. I don't really hear them across the street when they have their parties. Certain parties in different cultures, you know, they do tend to get a little louder. You can't really control that. It's like, how can you control 200 people sometimes? But I really don't think that should be the reason why they should stop their business and stop, you know, supporting their family. But I definitely just wanted to make sure I made mention of the college kids in the blue corner. Their property is like trashed. It's actually an eyesore. But I really think that should be a bigger focus in terms of what we have going on. If we're gonna enforce parking for that building, you know, we should definitely focus on them too and make a mention of that. But
May I
that's all
speak
wanted
to
say.
that, Chairman Peterson? And Attorney, may I speak to
Yeah,
that?
go ahead.
We have been on them quite severely.
Mhm.
They have the association that their
Fraternity.
Yeah.
they are not permitted now to have any more parties because of the complaints that were leveled against them, and there have been many. I've sent many pictures to code enforcement about it, because I live right around there too, and I pass it every day. So they have been made to clean up, and that's it. I've had my 2-year-old grandson all day, that's nothing. But they have been made to clean up. It doesn't look like it should. There's a broken window, there's something boarded up, there's trash laying all over, but until the code enforcement, you know, they knock on their door at least once a week. So it probably will, and it has gone to court also. So once those fines and penalties are leveled, it goes to the court, which I just found out today, that the court will decide what happens and what the penalties are. But as far as we are concerned, I'm on that like a big bird.
Yeah, which is
Okay?
concerned for me.
Because
like,
it's
I would
terrible.
Come home, we'll come visit her, and there'll be like broken glass, and I'm
Yes,
stepping on
trash.
my 1-year-old. And I know it's
Yeah.
coming from them,
Yeah.
and I'm like,
And
that's not even
yeah.
an issue across the street, it's more so right there,
Yeah.
since they've been there.
Yeah, no, we're definitely working on that. And there was a gigantic party, which I'm sure you're aware of, that was broken up by the police, and that was the last straw. There had to be at least 300, I would say 500 kids there. And it was horrible. And I would never want to live next to that. And that's why I'm so focused on that, because it's a disaster. And so that's being taken care of. Hopefully, you know, we'll keep on it and keep sending, the code will go over there when they're supposed to. But yes, that is being worked on.
Thank you, that's all I wanted to just adjust, because I noticed no one mentioned it, and I was like, it's a real big problem on that street.
Yeah.
But thank you.
Thank you, Ms. Yes, sir.
Raise your right hand. Do you swear that everything you offer tonight will be the truth?
Yes, ma'am.
Can you put your hand down, and what's your name?
Christopher Hawks.
Christopher Hawks?
Yes, ma'am.
And what town do you live in?
Egg Harbor City.
Great, thank you so much.
How's everybody doing tonight? I'm not
How you
gonna
doing, sir?
hold up too much of y'all time. I'm not a big talker like that. Some things that I just wanted to speak on, as far as the parking goes, I can say I'm the son that lives next door, 231 St. Louis. Me personally, I've given all of our neighbors, all of my neighbors across the street, right next to the hall, I've given everyone cones. And I actually tell them on the nights, like, listen, it's gonna be a party tonight, put your cones out early, or would you like for me to put your cones out? So I do try to take some type of initiative when it comes down to the parking. Because like I said, I live right next door, and there's been some times where I had to park down the street. You get what I'm saying? So I do try to take some type of initiative, but at the end of the day, you know, you can only control it as much as you can control it, and we do absolutely the best job that we possibly can to control the parking, to control the area, and all that stuff. When it comes down to security, I'm not just in the house. I'm walking around the building. There's sometimes I'm right inside the building because 9 times out of 10, whoever's having the event at the hall, some type of way, either I know them, they know my parents, and they always say some type of way, hey, you know, come get a plate, you know, just come say hello, you know, things of that nature. So I am in the vicinity like a lot. I'm in there before, I'm in there after, I'm in there during. I do have children that live with me. Besides me being a coach out here, I coach the Egg Harbor City Crusaders. I coach the Egg Harbor City basketball team as well. My kids, they do live with me, so of course, I want nothing but safety. So, you know, we're going to do everything in our absolute power to keep the community safe, to keep our neighbors safe, just to be happy neighbors. I just wanted to go and represent it.
Thank you, Mr. Hawkins. Is there anyone else from the public? Yes, sir.
Do you swear that everything you offer tonight will be the truth?
Yes, I do.
Thanks. And what's your name?
Joseph Geisenhofer.
GEI?
GEISENHOFFER.
Thank you.
Terrace, right across the alley from the hall. I know lots been discussed that probably has nothing to do with this application for a waiver or whatever. I served as a member on the planning board when I was on city council. I served many years on the planning board and the zoning board. So I know a lot of the complaints they have, and I have a lot of complaints about the property, come under the purview of code enforcement and not what's presented here tonight. There's a lot of complaints, noise, trash, people smoking pot, leaving themselves in the lot, drinking, trash left afterwards, blowing into people's yards, parking across people's driveways, mine, so that we can't even get out of our own driveway. That's all code enforcement. I understand that that has nothing to do with this tonight. But what I would say is that the parking is what it is. I'm a member of the Knights of Columbus for, I don't know, 30 years, 35 years. We several times had the parking lot regraded, Phil brought in, which I think you did also a couple of years ago or whatever. The parking lot is what the parking lot is. It's pretty much impervious. The water runs off. If it's paved, it's only going to run off more. At least maybe a little bit of it so it's into the ground, but not much. I know from having lived across the alley for 66 years, there's clay. There's lots and lots of clay and nowhere for the water to go. But all the other complaints aside, the parking lot is what it is. I think you're beating the dead horse here. Grant the waiver. Thank you.
Anyone else from the public? Second call. I'm sorry, sir, did you want to speak?
Hi, sir. Raise your right hand. Do you swear that everything you offer tonight will be the truth?
Yes.
Thanks. And what's your name?
Kenneth Purnell.
Kenneth, you said?
Kenneth, Kenneth.
P-E.
Purnell.
Thanks. And you're a Egg Harbor City too?
Yes.
Thank you so much.
Yes, I live about a half a block from y'all. These are two of the best people you can find. We've been raised in church. We've been in church all our life. We raised our kids up in church. Went through the Egg Harbor City schools. When we first got the building, we all came in that building. We had prayer. We prayed in that building. We prayed that we can be a blessing to the community, that some of the kids that was in the community will come out and we have an outreach in Egg Harbor City that we're working on now. We're doing things to help this community.
The Hawks is opening up that hall in a blessing. We go there, I have my 60th birthday party there. We, most of the events are church events, repast. There's once in a while a negative thing go on in there, but that's ain't gonna see. Somebody just spoke, it was 3 killings or 3 shootings in the last couple of months, I think it was. So it's been shooting happen. Nobody wants it, but it does happen. We're trying to be a blessing to this community. And with that hall there, I heard a lot of negative things about it, but I only know good things about it. And I'm only a block away from it. So I do ride by there every once in a while to check on it for them. There's negative things, there's good things, but the whole thing of this matter is just do right. Just do right by each other. This is all it's about, doing right. Judge him as you would judge your own brother. Let's just do right by each other. God is watching.
Thank you, sir. Is there, pardon me. Is there anyone else from the public wish to speak on this application? If there being no other public comment, board members, any other questions, comments? Carol, is there
Yeah,
a? I'm sorry, go ahead, John.
I'd like to add to this. I mean, obviously the parking lot's the parking lot, but well, Mr. Hawk spoke about what their spirit of the building was and their spirit, but the reality and the spirit of what your intent was aren't lining up everywhere. And I'd like to add that the restriction be 10 PM on the noise here as a requirement of this. I think that the neighbors who aren't here to speak, but we have spoken to all of us over the last 5 years. I think it's this board's responsibility to work on the behalf of everybody in the community, not just the applicant. I'd like to add that to part of the requirement.
Mr. Chairman, if I could just make a brief statement,
Go ahead,
closing statement. I think the neighbors and the comments that you heard from the neighbors are heartfelt. I think they express really the sentiment of people who live close by to it. We hear some positives and negatives. And the negatives are some negatives that you can almost attribute to any business that's ongoing, whether it's trash on the street, too much noise, but my clients have acknowledged that there are conditions, affirm that those conditions are imposed upon them and they need to adhere to it. I could say that, you live and learn, they didn't expect any of these problems or complaints when they opened up. They opened up in good spirit that they were going to have a good business. And now that these things are over time coming out, then they got to step up their game and do some things that are going to allay the concerns of this board and this township. And they're all legitimate conditions. We're not arguing that they weren't. I've suggested to the Hawks that, as far as the security to be on site, maybe it's not enough in the eyes of the board or the public that you should just have your son nearby to poke his head. If you're going to book a group that's going to be paying for the use of the room, you build in the cost of a security guard, and the security guard then is on site from the beginning to the end of the event, and I don't think they have a problem with doing that. They have to adjust, and they know that, and I think that they're willing to do that. They're an asset to the community. It would be an asset to keep them as a member of your community, and that's why we're asking that you grant these approvals. Thank you.
Can I say one thing? I'm in full agreement with the parking lot. I don't know why it was ever in there to begin with, to be honest with you, the paving. But can I just ask an honest question about the alcohol issue? Because it is an issue, and in October 17, there wasn't supposed to be alcohol, and I know it's been an ongoing thing, but what is your position now on the alcohol? Just to throw it out there. Just so we know and we're all clear, we all understand, because there has been a lot of concern.
She's asking about alcohol being served on the property. who's serving the alcohol, and how is that being addressed? Or they have a license, they have permission to serve alcohol? Do either of you have the answer?
When we purchased the property and there was a
bar,
liquor
a
license
liquor license.
that we could have purchased, but we told them, I'm sorry, from the Knights of Columbus, that we could have applied to purchase. We told them, because most of our events, for instance, are spread the gospel events, that we don't need a liquor license. We went on to tell them, though, we went on after the fact, to ask if we have an event where they want to serve alcohol, and that's kind of where it came in. We were advised that a person could apply for a one-day event certificate to be able to serve alcohol that would protect basically our interests and their interests as well in the event of something happening. So we've been doing that. We've been sending them to a site. Every time we book a party, if it's gonna serve alcohol, we make the people apply for this one-day event certificate. I think it's like $125 or something like that. And they apply for it, and it has different things on there. How many people will be at that party, for instance? Will they be alcohol served? Will you be serving the alcohol, or will they be bringing their own? All this is on this certificate. And that has, from what we understood, has sufficed for the past 5 years. So had we not known that wasn't to suffice, because again, our events, which are many personal events and community events or something, we don't serve alcohol. So again, when, am I answering your question?
Yeah, and I also, just to add to that, that if there is a catered event, the people that are catering the event should hold a license if they are in fact serving it, correct? I mean, I'm sure you were told that also.
Doesn't that license have to be through the city?
They just have to have, as far as Meg told me, they have to have a liquor license.
And I'm assuming, at least they've been acting on the assumption.
Well, the only reason I'm asking is because if we go back to the ordinance on 2000 and 2017, this should be stricken from anything new if this is the case, and that's why I'm bringing that up. It says applicant would apply and obtain a liquor license, which we just discussed. Until then, no liquor would be served at the site. So I just wanted to establish.
The would serve on the site.
Right.
Without a
A
license.
license. So I just want to establish that, you know,
There's-
we are serving liquor.
Well, hold on, there's a difference. I
Yes.
want to make sure we're speaking the same language.
Right.
Mhm.
There's a difference between a liquor license
Mhm.
and a liquor permit.
Right.
So does this site currently have a liquor license?
No, it's a liquor
Right,
permit,
exactly.
right.
So the question is, does everybody understand that before any liquor is served at the site, whoever's running the event has to get an ABC permit?
Right. I mean,
No,
that
but
would be nice to clarify that, because that's the assumption they're operating at, and that's what they sort of
No.
like that should be pushed.
What? I'm sorry, what did
If
you
the
just
person,
say?
if the group applies for and obtains the one-day license to serve alcohol at the wedding or whatever
Right.
it is that sufficient?
Right,
Does that-
but what I'm saying is it's just not jiving with what the original thing was, and it should not be in anything new. It should, the wording or whatever should be changed, because you are not seeking your own liquor license. So the guests obtain the liquor license, and the liquor will be served on the property.
So you understand that that's an obligation that your client always has?
They do.
Okay.
They do. Well, I guess I'm posing the question, would the city find that objectionable if that's the procedure?
Would the city find what objectionable?
Can a person who obtains the one-day permit to serve alcohol, and that alcohol then be consumed at the home?
Yeah, I don't think it's our purview to decide that.
Right,
I just
exactly,
wanted to
exactly.
say it was in the original 2017 agreement.
But the way it's worded, it says
Yeah.
whether on-site purchase or via bring your own policy, applicant will need to apply and obtain a valid liquor license. It doesn't say valid liquor permit.
So.
So
I
we
think
just
there's
want to
a-
make sure that's clear
I
what's
think there's
happening.
a fine distinction, because it says prior to that, it says should applicant wish to serve liquor on site. I think the distinction is the applicant
They're
is
not.
not
They're
serving
not.
liquor.
Right.
Their tenants are serving
Are.
liquor, and
Exactly.
their tenants
pretty
are seeking
twisted,
a
isn't it?
one-day permit for that when they do that, or they're supposed to be.
Or by extension, they're the. I mean,
No, if they rent out the facility, they're not serving alcohol in the facility. They're just renting the facility and then, so it'd be different if they were running a bar and they rented out a hall with bar service. Then they'd be serving liquor and they would need a liquor license for the facility.
Okay.
If they're renting out the hall and the tenants in the hall are bringing liquor and serving it to their guests, that is the tenant who needs their own one-day liquor license in order to do that.
So their tenant for each event would be
Correct.
required to have the ABC permit.
But I
Correct,
mean,
and
it
I think
just,
that's what they're saying. They provide that information and it's like hundred and
So can we
twenty-five.
clarify that in this
but I mean, it's,
resolution as well?
the prior sentence says, use will be by invite only and liquor will not be served on site. Period. It doesn't say by who.
I know.
It just says it's not served.
That section, the word is confusing.
But then after that, it says when the applicant wishes to serve. So I mean, if you read that, to me, there shouldn't be any on-site period.
Well, see, that's what we have to well, I don't know if we can clarify that, because I think that's just is what it is. It's just, yeah, it's just
Well-
that it should
Well, now's the
not be
opportunity to
in,
fix that.
it should not be in this like that. We didn't put it in there, the applicant did, I believe, correct?
There's, first of all, there's way too much cross talking. My first meeting, I'm trying not to be too mean. I was gonna wait until the public section was done and Mr. Friedman was done with his closing comments, and then when we had a discussion about what shape the motion should be, I was gonna make these comments, so before I delve into them, is there anything else you wanted to say, Mark, in closing?
No, there isn't.
Okay. All right, so I don't know why this is my charge. I think you gave me a fun outlet.
The city's outlet.
There's one over here. if you want.
That's all right.
Jack, you have one?
That's why we always had two computers going.
Yeah.
Okay, this
Try
is,
it down there.
this is a complicated animal that we're dealing with. This applicant, let me say it this way. It's a complicated animal when it comes to the conditions if you're going to approve the application. And let me say first, I always like motions to be in the positive. That, because it's very confusing when it comes to voting, if you say, I make a motion to deny the application, and the person who says yes or no, they don't know whether they're approving or not approving the application. So I always like motions to be in the positive. I move to approve the application. In this instance, it would be to waive site plan, grant the application to grant, to waive site plan approval, and therefore, not having to pave the parking lot. Then that way you know whether or not if you're voting yes, you're agreeing with the request, and if you vote no, you're voting against the request. What's tricky, really, really tricky, and this could be a law school exam, I'm not kidding. Question, it could be a law school exam question. This application is really a continuation of a zoning board application. I'm not even sure I had my head wrapped around that real clear before we started and we really got into the nitty-gritty. The applicant came to the board seeking zoning board approval for a use variance, and we all know that site plan would generally come before the planning board unless there's a use variance involved. Then it's got to go before the zoning board. So what has struck me tonight, which I think the board needs to take into consideration when deliberating and having your motion discussion, the applicant had to come to the board for a use variance because it wasn't deemed a permitted use because it's not a house of worship. And it wasn't deemed a permitted continuation of what the Knights of Columbus were doing. So they had to ask the board, can we do this new thing on site? And what was that new thing? Having staff meetings related to a radio station. And I don't have to read the whole resolution to you, but that was the thrust. And part of what they wanted to do was rent the hall out to people who wanted to rent it for whatever purpose. Funerals, repasses, meetings, weddings, just neighborhood gatherings. What the board has to decide tonight is whether or not the language in the resolution that says, and this really struck me as I was hearing everybody going back and forth, and I hear the struggle, you know, I get it. It's a hard question. But there's language in the original resolution that says, in the specific conditions, number 6, applicant will, not may, will apply to the board for full site plan review within 30 days after receiving approval from the Pinelands Commission. What that means is the board that sat back in 2017 knew the applicant was coming back to say, this is what the site will look like to support what we're doing here and what we say we're doing here. And we've heard lots of great things about the applicant and what they're doing and what they want to do. But we've also heard things that causes the board concern, and I don't need to reiterate that. You've all heard it. And you've heard some, not a lot, but you've heard some concerns from neighbors saying these things are a concern to us, and if we could throw in what the college kids on the corner have to do, that would be great to get that in there too. So we need a motion that says that the application to waive site plan approval or review rather, and from the obligation to pave the parking lot conditioned upon, and then we need to come up with a list of conditions that the board wants to see. And then we need a second, and then we need discussion. And because it's our first night here guiding you, the discussion is really important because we can't make up the conditions for you, and we cannot come up with the reasons why you want the conditions and grant or deny the application. I'm happy to answer any questions about what I just said, but it's a really important distinction about waiving site plan, knowing that it had been a condition of the last application in light of what you've heard tonight, both pro and con. So you got a job ahead of you. Because whichever way you go, we're going to need to explain on the record why.
So if the board, just for clarity, for myself, if the board is fine with waiving, paving the parking lot and waiving the site plan, because they obviously never got Pinelands approval, so that's a default. Then we can also list any other conditions we may want to impose.
Yes, and if you go astray, too far astray of what is reasonably related to this application, I'll let you know that.
So I'll let you know the two things and you can come up with the verbiage. Go ahead.
What if the board doesn't waive the full site plan? What's the next step for them?
Well, then their application tonight is denied.
Yep.
But the board's gonna have to explain why they would deny that, based on the evidence before it tonight.
Number 6.
But then if you go back, like you're saying, it's a zoning issue and they're not meeting. It's not just the paving at that point.
And that's something you want to address to Ryan. Other than paving the parking lot, what other checklist items would there be to a site plan review that you had anticipated? Not you personally, because you weren't here. Sure. But back in the day, what does Egg Harbor City require for site plan review?
So typically for existing sites, we either entertain a waiver of site plan or we just require a fairly basic plan depicting the improvements that are being requested and are being required. I mean,
Would that include delineating the number of parking spots based on
Yeah,
occupancy?
we've done that for numerous prior applicants, required that they delineate parking spaces even if they're not improving the lot. For existing paved parking lots, we required that they restripe, but that all of those are typical requirements of the school. So.
Other than that, what is the board not saying that they would see if there had been a site plan submitted?
I don't think there was any other changes.
Yeah, I don't think that the board had requested any other information on the site plan. It was just to address how I mean, it would have been the stormwater management and the paving of the lot and how it was laid out. We want to see.
And if you
things like
don't do the
dimensions.
lot, you don't have to go to Pinelands.
Correct. If you don't pave the lot, you don't have to go to Pinelands. That was the only trigger to go there.
Exactly.
They were able to do the ADA spaces and the ADA ramp without going to Pinelands because it was less than 1,000 square feet of new impervious, less than 5,000 square feet of disturbance. Those are the only site conditions that I can recall with the ADA spaces and the ramp, which were required before they could open, and then the paving of the parking lot, which was required.
I think due to change of use, we also waived not having to do curb and sidewalk on the back or all the shrubs and bushes and beautification.
Yeah, I think we.
So we granted quite a few waivers as well.
Yeah, I think we typically do not have people supplement landscaping with the existing site unless they're doing pretty extensive renovations. We never require curb and sidewalk on the terrace on the front side. I think they have existing curb and sidewalk, and I think they replaced some sidewalk, if I recall correctly, as it just close to their entrance. Anyone, even for a residential house, if they have non-compliant sidewalk, they have to replace that. So I'm sure that was required as for this. Do they need that where they got CCA?
Wouldn't that solve that if we're willing to waive the parking lot? And from what you read there, it sounded like they would have to submit a site plan within 30 days once they developed what the parking lot was going to look like to come back to us to present it. So doesn't that make it simpler if that's part of the waiver, that they don't have to do the parking lot?
Obviously.
Then they don't need the full site plan.
And that's why I asked Ryan to clarify what else would be missing. If there was a checklist of 12 things that the board wouldn't be seeing that you had anticipated seeing, that is a lot different than what Ryan is clarifying. That if you agree that the parking lot didn't have to be paved, they shouldn't have and probably now regret offering to pave it. They wouldn't have had to go to Pinelands. So the fact that whether for whatever reason it took so long, it doesn't matter at this point, right? And what are you really missing? Nothing. The two important things with regard to the handicap and ADA access were done before they got their first TCO.
So are we ready to offer a motion and then have discussion?
You asking me?
Yeah.
Okay. Wasn't sure. I think so. I think from what I've discerned from the board, that the motion should sound like this, that the application seeking to be relieved of full site plan review, and because they are asking to be relieved of their obligation to pave the parking lot for the reasons already set forth on the record, I'll put in the resolution, is granted. That doesn't mean that you're granting it. That does not mean I'm telling you to vote yes. I'm just saying, if you vote yes, you agree with what I just said. If you vote no, you're voting against it. It's for clarity's sake only. Conditioned upon, one, the applicant complying with the new or with the anticipated noise ordinance.
So I made a change to that. The new ordinance says 11 PM and I asked for 10 PM due to the history. So, but that's part of the terms of, that's what I proposed as part of being fine with the other conditions.
So you would like this to be your motion?
Yes.
Okay, so the motion is to, and I'm not saying you have to vote that way, but approving relieving the applicant from submitting a full site plan for review, no longer having to pave the parking lot for the reason stated on a record. complying with the anticipated new noise violation, except we're backing the time off from either midnight or 11 down to 10 on all nights,
Yes.
I think
on all
that,
nights.
excuse me for 1 second, but wouldn't that be a council issue if it's an ordinance?
That because they're able to,
Just asking.
No, in the event that anyone thinks that the motion that Mr. Garth is putting forward is not appropriate, they shouldn't second it. And then I'll continue to massage the language.
I just think that may be, and I'm not a lawyer and I'm on board with what everybody's talking about here, but I just think that might be overreaching. It is, I gave you the ordinance. And it was 148 what was, I don't have it.
I mean,
in
it's
front of
only
me
an
now.
hour more.
I gave you the paper. What is the ordinance number?
Or 2 hours.
I suspect that whether it's in the motion or it's not in the motion, if you pass an ordinance, they have to comply with it.
Right,
It's a
but it
condition,
doesn't,
it's a
that ordinance does not say, I don't have it in front of me is what I'm saying. I gave it to you. It doesn't say 10 o'clock there. I can't recall
It
exactly
says
what it says.
10 PM Sunday through Thursday,
Does it say
12
10?
12 AM
You
Friday and
have it?
Saturday.
Okay.
however, if we have an ordinance for curbs, sidewalks and other conditions, this board can also waive those based on an ordinance. So I feel that this is the opportunity where if the client is willing to accept those terms
Yeah.
and we accept
We're
it,
not
then it's a
in
neutral.
I'm sorry to interrupt. This is not a time for them to accept or not. This is a time where we're making a motion that you're hoping that everyone will agree with. You understand that if no one seconds your motion, I'm going to reword it.
Okay. So that and to have the liquor license displayed for each event. Permit displayed on each event, so that way, when people show up, whether it's the police, code enforcement, or anybody else, they know that those terms and conditions are being met.
I mean, we
I don't think that's necessary.
but they're not.
Why don't we do it this way? We seem to be at loggerheads. Let me formulate the motion. If somebody would like to say that's my motion, then we'll go that way. And I'm not, but this is not working for me and I'm old.
Karen, I have a question.
Yeah, of course.
Can this board change a city ordinance? Because a city ordinance has to be read twice and voted on by city council, so
Mr. Garth was not suggesting that we change an ordinance. He was simply suggesting that the applicant agree to more stringent terms. That's permitted, but we're past the time of discussing things with the applicant, which you should never do anyway, but every board I ever represent does it. So we're gonna go back to the way Carol does things, and then you guys can go from there.
So just to be clear, 12 to 8, it's Friday and Saturday are the hours they cannot operate. And then the rest of the week, include Sunday to Thursday, I guess, would be 10 PM to 8. They're the hours that they cannot
it is 10.
operate.
And,
So
I was asking
the
Friday,
only
Saturday.
the only 2 days we're in discrepancy here are, well, Friday and Saturday. They're still 12 o'clock, the way I'm seeing it. So this is an ordinance that was read at city council. And the second reading will be,
well, we've already gained 2 hours, John, because in the original, it was
I
2 AM.
get that, just like we were trying to do with the Friday house and everything else, trying to make it work for everybody, to include the residents and to spread the gospel. Now, I think it's a fair compromise for everyone in that neighborhood.
Well, in all fairness, and it doesn't matter to me one way or the other, but we had public testimony and I don't recall anybody.
Jack, I sat up here for 5 years listening to this in public testimony, so I disagree with that statement.
Well,
And
this
that's
is the
fine.
place that the business is transacted, John, not on the street.
Well, that's not true. I'm here to represent the community regardless of whether I hear it on the street or not here.
We can only have we can only vote on the testimony that's before us,
That's not true.
not on hearsay.
All I'm gonna suggest right now is that we are supposed to comply with Robert's Rules of Order. This is discussion that should happen after a motion's made.
Okay.
So. The motion that someone should make is that the application to waive the prior requirement of full site plan review and to pave the parking lot after obtaining Pineland's approval is granted, and on the condition that, number one, obviously, all the other conditions in the prior resolution are met, acknowledging that prior conditions 7 and 8 have been met, that the applicant acknowledges and will comply with the anticipated new noise ordinance. And I'm going to end it there because everything else I've heard the board talk about tonight, about having to be included in the resolution, are already in the old resolution, and I'll reiterate them. We've heard conflicting testimony about what security is required versus what they're providing. One applicant related individual said one thing. Another applicant related individual said another, which complies. And we'll just reiterate those old conditions. They have to comply with them. And I just say this, the board, just keep in mind that whatever the applicant doesn't do, people who know about the violations need to reach out to either police or code enforcement. That's not the board's job. So that's the motion. If anybody wants to make that motion, you can make that motion. If nobody does, then we can entertain another motion.
I asked for 2 things. Are we?
The only next step is, and I don't mean to cut you off, sir. The only next step is either somebody makes that motion.
I'll make the motion.
Okay.
With adding that the alcohol license or permit be present on site. So if someone is called and the police show up, there's not one there, they can put it in their police report so that way the zoning officer has some teeth to do his job. I think that's important.
That's not really following Robert's Rules of Order, but for tonight's purposes, just so everybody can we can either move on to another application or end it. I'll let it go this time.
We aren't really strict on Robert's rules.
Okay.
And I understand it, sure.
The only reason I bring it up because it can get way out of control.
And I asked for the 10 PM. Change, not the ordinance. That's my motion. If they don't want to vote for it, they don't have to. That's. the
So
motion.
is there a second?
For the ordinance that Carol read,
Mhm.
that,
For the motion.
And what,
I mean, for the motion, I don't think, I think the 10 o'clock could be a deal breaker on Saturday. and
That's what I'm
Sunday, so
saying.
I'd keep that out of it and get the business.
I need
squared away.
somebody
So
to either
we-
make my motion or not.
yeah, either agree with John and second the motion, or don't agree with John and don't second, and nobody seconds.
No,
it.
we're not to that spot yet, and believe me, this transcript is going to become very important potentially. I've suggested a motion. Somebody needs to make it or not.
And the 10 o'clock is not. in
It's
that
not
motion.
part of the motion that I've
Then I'll
stated on the
second.
record.
I'll second.
No, somebody needs to make it. I can't make a
Oh,
motion.
I thought John
John
made
made
it.
I just
No,
made
he
it.
didn't make my motion. He
Okay.
made a motion,
He
and
added
added 2 things
he
to it.
added it.
All right.
During
So
discussion,
that's my motion. I don't understand. You're confusing me.
I'm sorry.
Read the motion again, read the motion again.
If I take your verbiage and I add
I'll be here
those
till
2 things as my motion,
I think what she's saying is, you would introduce that, somebody would motion for it and then second it, and then you, during discussion, would recommend those changes. And those changes could either be incorporated or not. Is that a fair explanation, Carol?
Yes.
Okay.
I assume the motion was, we're accepting it, not that there was an opportunity to add to it.
I'm just gonna simplify it for you.
I make that
Everybody ready?
motion without any
No.
addition to it.
Read the motion again, Carol. Please.
No, that's no, I just want to make sure I can do. The motion is that somebody needs to make, is to approve the application to waive full site plan review. And as a result, the condition to pave the parking lot, all of the prior conditions are in full force and effect. The applicant has already agreed to post the alcohol licensing permitting that is obtained, so there's no harm in that.
So I make that motion.
Is there a
And
second?
I'll second hers.
Now there's a discussion. Now's when we can talk about modifying it.
I'd like to make the modification that we change the noise ordinance aspect because of where it's located in the city and past history to 10 PM on Friday and Saturday. I think that's fair and reasonable.
Is this the time when I ask you? So you're saying that just this business has to go until 10 o'clock?
That's what he suggested. And understand, it's not even, I want to make sure I understand what Mr. Garth is suggesting. A noise ordinance is about sound. That doesn't mean that the party can't continue until 4 AM as long as it's not
Disruptive.
loud.
Well, their hours of operation are listed in here anyway.
Right.
So it's 8 to 11.
Exactly.
8 to 11 Sunday through Thursday, and 8 to 2 AM Friday and Saturday. That's hours of operation.
So
not-
people can be in the building until 2 AM. Under the anticipated ordinance, they're going to be able to play music or whatever until 11. Mr. Garth is suggesting that if anybody's disturbed by the noise, by 10 o'clock, they can contact the police and ask them to turn the music off.
But even if it's not in the resolution, that could still happen, right?
Up starting at 11.
But I mean, if it's abuse.
Excessive
Oh,
noise,
of
it doesn't
course.
matter what the
Yeah,
hour is.
That's what I.
Yes,
And
of
the
course.
one problem that I have with the 10 o'clock, John, is that there's other businesses on St. Louis Avenue. There's a new one that's supposed to open soon, and they would have a different time. than-
I don't even
than
know
some
if what
of those.
Mr. Garth is suggesting, with all respect, is constitutional. I'd get to that after, if I heard anybody else getting on board with this. You can't single out
But
one.
there's other businesses.
You can't
that-
do it.
That's what I was trying to say.
Yeah.
You can't say
Part of my
one business.
concern is,
Yeah,
it's akin to like spot zoning.
exactly.
Now, my issue with this, I think it's cleaner if we simply say that they have to comply with all local ordinances and as far as alcohol, with state agencies. At least they're on notice that they have to comply. And before, there was some question, so if there's gonna be a permit issue, like, they say they're not doing alcohol for their own personal stuff. But if someone comes in and they're having a party and they want to have alcohol, that at least they take the steps to make sure that they are compliant.
But that's not what their original,
I know what you're saying. I'm saying moving forward.
so then you're changing this.
I'm saying moving forward, if we say, hey, you be aware, because that's something we could always say. We can always say, you gotta be compliant with local ordinances and state law. We can always say that.
But Gladys's motion keeps it the way you're saying, like, I think.
I'm suggesting that,
Is that right?
same way he suggested, that we add the language about compliance.
That would be in all my resolutions.
So
Should
this
we have a motion in a second?
use will be by invite only and liquor will not be served is still in this then? Is that what we're saying?
Let me make sure I'm reading the same page you are. What page are you on?
Page 3 of 11, number 4 of the original.
Applicant indicated, all right, well, let's read it, because this is under the heading findings of fact and conclusions. Applicant indicated that the standard hours of operation proposed use would be blah, 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 blah. Use will be by invite only, and liquor will not be served on site. Should applicant wish to serve liquor on site, whether through on-site purchase or via bring your own, applicant will need to apply for and obtain a valid liquor license. But hold on, there was other discussion. Okay, so again, first night was not here back in 2017. That is clearly limiting the applicant. I don't know that, and I could do some research if you want, but I don't know that you can take a site, any site, and prohibit someone from applying to the ABC for a one-day permit. And I'm sorry, who was I talking to?
Me.
I'm sorry. So this says that the applicant came to you in 2017 and said, we're not a liquor-based place. We're not a bar. We're not gonna do this every Sunday thing. But I don't see that limiting any anybody who wants to rent out there.
Okay, just
Site.
asking.
Yeah, that's not the way I read it. If you guys, people, however, get late,
I think that's
if you have a
exactly how it's
history.
being handled right
Yeah,
now.
okay.
Further discussion.
So I just want clarity for this and anything future. So the board can take an ordinance and we can downgrade the ordinance to requirement, and that's not, as you said, constitutional. But I can't make an ordinance more strict or set a term that's more strict than the current ordinance.
No, actually, the opposite is true. You can take a law and make it more stringent if you're a governing body. You're not a governing body.
Okay.
Let's say that the federal government said that on a road like the White Horse Pike, you can do 70. Egg Harbor City can say, no, in Egg Harbor City, you're only gonna go, if it was not a federal road. They can make the speed limit lower.
Okay.
They can't say, screw the federal government, you can blow through at 90. What you're suggesting is in a town, and specifically in a neighborhood where the city is about to tell people they've got to turn their music down at 11, you want to tell one business in the neighborhood that they've got to quiet down by 10.
Okay.
That's not.
I get it, I guess it's an ordinance, but there's many ordinances that we give waivers to all the time. So,
What you're suggesting is not a waiver of an ordinance, and I don't know what a waiver of an ordinance is.
somebody wants to build a trash.
I think it's
concrete
saying
trash
we
container.
relieve requirements that
Yeah,
are.
variances or waivers. Okay, I'm sorry.
Maybe I just need a new class after this because I'm confused with what we're supposed to do and what we're not supposed to do that.
And I take the complete blame for that.
Okay.
My number one job is to make sure you don't get sued. And what we've heard tonight is there are other businesses in the area. And if you tell one business that they've got to pipe down by 10 and everybody else can be whooping it up until 11, you're gonna be sued. That's the easiest way I can say it.
Okay. Well, let the phone calls roll.
I'm sorry?
Let the phone calls happen then, because it just, I'm trying to make sure that everybody's here. The client, us, the residents, that there's a happy medium, but if we can't, we can't. I don't think they've been good stewards to this community for the 5 years they've been operating. I take offense to the term that they were working in the spirit of being good stewards to the community. So whatever ordinance the board wants to do, I guess is what we're gonna be stuck with.
So we're having discussion. Is there any further discussion? So there's a motion and a second. No further discussion. We'll have a roll call vote.
Mayor Jim Petty,
Yes.
Mr. Peterson.
Yes.
Mr. Chambers,
Yes.
Mr. Walker,
Yes.
Mike McKenna,
I'm gonna vote no.
Mr. Guard.
Yes.
No, Mr. Guard,
Oh, sorry.
Mrs. Torres,
Okay, but you know, I have a yes already.
Mr. Keener,
Yes.
Mr. Frick.
He can't vote.
Oh, that's right.
He cut himself out about an hour and a half ago.
Right.
He's wondering why he's still here.
Why are you still?
He's not even.
So the waiver of the parking lot and what they've asked for was accomplished.
Clarification,
Yeah.
it's a status.
Yeah.
That
Towards
the
the end,
condition
right,
stating that
the
there has to be
towards the
compliance with the
entrance.
new ordinance. Is that the task, that compliance with the existing conditions?
And posting of the liquor permits that may be obtained for any particular event.
The display of the liquor license for the event. That's it. That's pretty much it.
Passed, right?
Thank you. Folks, I know that it's late, but I think the board needs to stretch their legs for 5 minutes and we'll come back. I'm sorry to hold you guys up. I know it's been a long night.
It's their fault, they weren't ready. I gotta get.
I don't know about you, but I like her message.
And she said she wants to do something.
What they say. Oh, it's going.
We are.
Look, I don't know how you do
Operation, we do it with, you place the container, the ordinance says you can't, we do it with doing a trash dumpster. So we pick and choose based off of a lot of variables. Impact to the community, rather than taking business seriously. It's not like we're doing it without the thought process and the impact it has on their surroundings. That's why. And so I do volunteer for it.
Oh, they have to have insurance.
Issues that happen to them, they have to have some integrity. The person in front of them. A lot of it talk differently.
They're on a hook. They don't.
This is where I'm concerned.
We can't get them.
That's not start there.
They're gonna be looking for alternate.
I had to bring my sleepwear.
Listen, the last meeting we had, we were here like maybe 15 minutes.
Right, it was great. All right, we're on a Monday night. Yeah, everything goes back. It's round zero. Every problem goes to.
But we said, yes, you don't have to require other people to.
That's why it's for the future, once we get a resolution and it's signed. We have Doris and that.
And the city could. This was existing. That's what she triggered. So trying to. So, we're gonna get one.
Yeah, but still, but they're printing that up.
Continue to be as my. So that's just a statement that the entity is. They weren't.
That's a city council. I'll drop that.
I'll put you in there.
Depends on their use of this. They're using it for commercial purposes. You know, their tax organization, that's not a tax. Properties that
And that was.
Yeah. I looked at and I realized it was, it was like, when the report was, should have been written. So I did not issue a report for the last, only attended, and I was not at the meeting.
Really?
Yeah. Yeah, because my dad passed away. This is the meeting of August 15th, 2016. My dad passed away. I did not attend.
But you gotta,
Like, it took me a little while to try to figure out.
and I don't wanna make that.
And I finally realized.
That's why I want to
I told him kind of said that, okay. Because it wasn't. We were planning to go back to look at it.
No, he's still around.
Okay, this is just for you, for instead, for them to come back with the same plan.
Good for her.
You should have had.
Right? There we go. His son, who's supposedly in charge of security. My daughter said.
Hey, Lisa, on that, one and
Yeah, and one down the road too, because this is a redevelopment plan. Brian will explain that to you.
We got
You say you provide.
It should be straightforward. It's gonna take some time.
Hopefully with our history of being a nice gentleman. I'm a little worse. When she said no. Right, you said-
Yeah.
Did you say he's trained up? He doesn't really. It's not necessary. I didn't, I said he didn't. It's impressive. Maybe you'll learn from it. The man never does anything.
Okay, folks, we're ready to get started again. I'm sorry to interrupt everybody. I know it's been a long night.
I love him. Because he knows what he's doing.
Okay, application 2024-01, Lake Harbor City Partners.
Good evening again, members of the board. Michael Arias in front of the on behalf of the applicant, Egg Harbor City Partners LLC. This is an application for preliminary and final major site plan approval, conditional use approval, and bulk variance relief in connection with the establishment of a approximately 3,500 square foot class 5 cannabis dispensary at the subject site. The property itself is located at 10 Philadelphia Avenue. It's block 319, lot 5.01. Just to orient the board a little bit, it's immediately behind the Wawa convenience store that recently been built on the White Horse Pike. The application, as I stated, it is for preliminary and final site plan approval along with conditional use approval. These class 5 retail dispensaries are conditional permitted uses within the zone. the applicant's position and as articulated by your planner, that we are in conformance with those three conditions, and our planner can speak a little bit more to that during our presentation.
Can I stop you, Mr. Lario? I just want to make sure procedurally we're all on the same page. I just want to state for the record, it's 4 before 10. We know who's here tonight. I don't know the depth of your application or how many witnesses you have. The room still has a number of people. It looks as though there's going to be a lot of members from the public. Are you sure that you want to proceed knowing that it's probably going to spill into another meeting?
So we would like to proceed, and the reason why I feel that, again, this is a permitted use, there's minimal variances necessary. We believe that it has been presented, obviously, given the late hour now, presented in its entirety. Obviously, if we hit some type of log jam, that's a different story, but we think on the whole, this is somewhat of a straightforward application, so we would like to proceed.
So do you guys have a stop time that you hold to or no?
I don't, we've never had a stop time. We're going to finish the business until we're done.
Okay.
So again, not to belabor the point, with me tonight, I have a representative of the applicant who will provide operation testimony, Mr. Jim Angeloni. I have the project engineer, Mr. Chan. I have the project planner, Mr. Steve Falk. And we also have our traffic engineer on standby, just in case any questions arise from the traffic perspective. That's Mr. Andrew Vichio. I'd like to start, and Mr. Chairman, I apologize. I don't know if the preference is to swear all the professionals in together or as they appear.
As they appear.
Okay. Then Mr. Angeloni?
You raise your right hand. Do you swear that everything you offer tonight will be the truth?
I do.
What is your name?
James Angeloni.
Mr. Angeloni, first, can you explain your relationship to the applicant at Carver City Partners LLC?
I'm the managing member of the LLC.
Okay, and you're familiar with the proposed operations of this Class 5 retail dispensary? correct?
Yes, I am, yeah.
Now, a Class 5 retail dispensary, that is a license that's issued by the state, the New Jersey Cannabis Regulatory Commission, correct? Okay, and that would be required in order to operate this Class 5 dispensary at the site.
Yes,
Now, that application's been submitted, but we don't have that license yet, correct?
not at this time.
Okay, now, that would obviously be a condition of any approval that we would obtain that Class 5 license in order to operate this site.
Yes,
Okay. Additionally, there is a municipal license that is required for this Class 5, correct?
correct.
Egg Harbor City, the governing body issues that license. We don't have that license yet, but as a condition of any approval, we would obtain that license prior. We don't have a choice. We would have to obtain that license prior to operating.
Yes.
Okay. So let's turn to the specific on-site operations of this facility. If you could, start briefly with day-to-day operations, the days of the week that it's open, the hours of operation, number of employees, those typical questions.
So the hours operation, Monday through Saturdays will be 7 a.m. to 11 p.m. Sundays 9 to 9. 20 employees, they'll run 2 shifts, 8 employees each shift.
You know what, sir? We're all doing minutes by hand. Just slow
Okay.
down, just a touch.
Let's start from the beginning.
No. We're
Oh,
up
you got
to
it?
speed.
Where to pick up?
20 employees.
2 shifts. 8 employees, 2 security guards each shift.
And just to confirm here, we're talking a Class 5 dispensary. It's really retail in nature. There's no on-site consumption proposed here. There's no odors, there's no noise. I mean, it operates like a traditional retail facility, correct?
Correct.
Okay. Obviously, security is an important component of these proposed uses. The security plan for this proposed use, it all has to be sent to the state, correct?
Correct.
So they'll review the security plan as part of that license application, and there's strict rules on the cameras, the lighting, et cetera.
360-degree cameras, 2 security guards at all times.
So let's talk about the cameras first. There'll be cameras outside 360 degrees,
Correct.
cameras inside,
Cameras inside.
and those will be monitored
monitor with a separate room for security inside the building that happens to be monitoring all the cameras.
And those camera feeds also feed to the state as well. They have access to those
Yeah,
feeds as well.
absolutely.
To monitor.
Yes.
Okay. You also said security personnel, 2 members on site at all times.
At all times.
And again, that'll be monitoring both what's going on in the sales floor and also monitoring the camera feeds as well.
Camera feeds as well.
Okay, and again, all of this will be compliant with the state regulations, correct?
Correct.
And not only at the time of our application to the state, but we will have to maintain that security plan going forward in order to keep our license.
Correct.
Okay. Deliveries, getting the cannabis product to the site. Can you speak a little bit as to how deliveries work?
Usually between 1 and 4 deliveries a day, to the van or a box truck, unmarked. And that this, so at this site, will come in, pull up on the side of the building, security guards, or meet the delivery truck, bring the product into what they call the vault area. It's on the.
So private access.
Private access. Secure and into the vault area inside the building.
Okay. And how long on average do those deliveries?
15 minutes. 15 minutes.
Okay, and there's tracking in this product as well. The state actually tracks all of these shipments. They know where all of these deliveries are at any given time, correct? Okay. Now, we don't have a set schedule for delivery. Obviously, for security purposes, it fluctuates somewhat, but usually it'd be during normal business hours.
All
correct?
in one building. Yeah, that's-
Okay, now, we also anticipate there to be deliveries that any normal retail facility would have, Amazon, UPS.
And mail, yeah, they all, they're regular deliveries as, and any business has, and they will come through the front door.
You're not anticipating any type of 18-wheelers and tractor trailers, anything like that? It's
Absolutely.
small box type delivery.
Correct, yes.
Okay, trash and recyclables, and I think it's really a 2-part question. So I'd like to focus first on the disposal of cannabis product. That's also regulated by the state.
Correct.
Can you speak a little bit as to that?
That is also a delivery system, so anything that's being disposed is, again, we have a box trucks or a delivery, come take the product away. Again, that's all regulated by the state and how that gets disposed. So on site, it'd just be natural, normal trash and recyclables.
So for the cannabis product, there's actually somewhere within the building that cannabis waste is stored until it's time for it to leave the site, and then it's removed from the site through regulated process.
Regulated
It doesn't end up in the garbage.
Does not.
Okay, but we are proposing a trash enclosure with a typical normal trash removal.
Correct.
Okay, and that'll be once, twice a week as needed?
As needed, yes.
Okay. Landscaping and maintenance here, I know obviously the site itself, we're proposing a number of trees and shrubs. The landscaping will be maintained as part of this proposal, correct?
Yeah.
Private contractors.
Private contractor, landscape companies,
Snow, they'll plow out the parking lot and maintain the area.
maintain the site, correct.
Mr. Chairman, those are all the questions I have for Mr. Angelo.
Board members, any questions?
What kind of cannabis trash would you have disposal? What kind of cannabis disposal would you have?
That gets moved, it's just from an expired stuff, if stuff is not moving.
Falls on the floor, product that falls on the floor,
Yes.
that you can't, you have to dispose of it, but you can't just throw it.
You can't throw it in the trash.
Okay.
The physical address for this class 5 license is on Philadelphia Avenue.
So we actually, our engineer can come and show, it's 10 Philadelphia. It's the address.
So, yes.
So, Ryan,
Mhm.
our ordinance is still 1 on Route 50, 1 on 30. You guys aware of that?
Yes. we are.
Yes.
Okay, just want to make sure.
Mhm.
Yeah, I addressed that in my report as well.
So the trash enclosure will be built to the engineer standards of fireproof
Correct, yes,
enclosure, that maintainable.
yes.
Any other questions?
Next is our project engineer, Madam Chair.
Raise your hand. I'm sorry. Do you swear that everything you will offer tonight will be the truth?
I do.
And what is your name?
My name is Aaron Chan, last name is spelled CHAN.
Thank you very much.
If you could, before we begin, can you provide your qualifications to this board?
Of course. I am a project engineer with Stonefield Engineering. Business address is 15 Spring Street in Princeton, New Jersey. I graduated with a bachelor's in civil engineering from the College of New Jersey. I've been practicing in the field for the last 10 years. I'm a licensed professional engineer in the state of New Jersey. I'm also a certified municipal engineer by the NJSME. I've been accepted into over 25 land use boards across the state and provided expert engineering testimony in each of these. I worked on over 20 retail store projects, also similar to the size and scope of one before you here tonight. I also had the added benefit of working on a law.
Mr. Chairman, I offer Mr. Chan as an expert and professional engineer.
We recognize this.
Thank you. I'd like to start first with just orienting the board. I think generally we know where we're talking about, but if you could you just show existing conditions, what's out there right now?
Sure. So this is an aerial exhibit that's prepared on March 18, 2024 by Stonefield Engineering. All you're seeing is the existing condition of the site. I think the important thing to note here is the frontage along Atlantic Avenue, Philadelphia Avenue. There's currently no access, no curb cuts on any of these areas. It's part of during the Wawa project, 6 terrace was vacated and all the utilities under there was placed under a public utility easement as part of the Wawa project as well. There's a set of drainage basins for the Wawa development to the southerly portion, as well as the corner of the site that's also been placed in a drainage easement. Beyond that, it's a vacant pad. It's pad ready, for future development. And part of the Wawa project, at the time, it was always contemplated that this portion of the site will be developed with a future development, typically a retail or some kind of similar or complementary use. So that's kind of why we're here.
And just to confirm, the site itself is in the highway commercial zone in its entirety, correct?
That's correct.
Yes.
And for the record, can we mark that A1, please? And identify it in the packet? Is this, does anybody know what page in here it is, or do you just want to?
So this is actually.
Okay. There you go. Do you have an extra copy you're gonna leave with us?
You should know.
Wonderful. And what's the date on that?
This is March 18, 2024.
Again, just to describe it, it's just an aerial.
It's an aerial exhibit depicting recent site conditions.
Thank you.
So I'd like to turn now to proposed plan development.
So I'm trying to find a balance between talking quickly, understanding the hour, and also not going too fast, but.
Slow you down. So
This is-
just for the record.
The description's wonderful. It was the numbers from Mr. James. The numbers were hard to catch that fast. You're doing fine.
Okay,
And this is gonna be A2?
this is A2, and what A2 is. A2 is prepared on March 18, 2024. A2 is titled site plan rendering. Site rendering exhibit rather prepared by Stonefield Engineering, and what you're seeing is the proposed site with the added benefit of some color, and also the proposed landscaping to give the board some clarity and context as to the site that we're.
So that was also prepared yesterday?
Correct.
So the first 2 exhibits that we have, just so we're clear, are not in the packets that were correct. Okay.
And to be 100% clear, this is, the proposed site along with the proposed landscaping. Both of those items were part of the site plan, and it's just kind of interspaced and colorized to make it a digestible visual.
All right, so let's start first, the building itself. Can you talk a little bit as to the proposed building?
Sure. The proposed building is approximately 3,500 square foot. The general dimensions are 58 by 60. Generally a rectangular box is centrally located along the site, understanding that there are 2 easements that would kind of need to avoid encroachment on. So it's generally placed 50 feet from the Philadelphia Avenue property line, and then I believe it was 58 feet on the Atlantic Avenue side. Fully complying with the front yard, and actually all of the bulk regulations under the HC zone, except for the rear yard opposite of Atlantic Avenue, where 30 feet is required, where 25 feet is proposed.
And that is the shared property line with the existing Wawa, the parking lot.
Correct. That shared parking lot is along the row of parking adjacent to the Wawa development. You also know the trash enclosure here, so, and then the pylon sign with the gas prices.
Okay, so let's talk about the parking on site. First, we can talk about access and then the proposed parking.
Of course. So access to the site will be provided via a full movement driveway along Atlantic Avenue. It's generally in the same approximate location as the formerly Six Terrace. And that'll provide access to an interior parking field. It's going to consist of 19 parking spaces, where your ordinance requires a total of 13 parking spaces. All of these stalls, as well as the drive aisle, will be industry standard, dimensions, complying with city ordinances.
Okay, and the traffic engineer, I know he's here, he's reviewed this, he finds that it will allow for safe and efficient circulation on site, the proposed parking lot.
That's correct.
Okay.
And then the next component is actually the loading space that's placed in between the building and the Atlantic Avenue side. The approximate dimensions are 14 feet wide by 45 feet, which meets the city ordinance on the single unit truck loading dimensions. And at the end of that loading space is the trash enclosure. It's a fully enclosed trash enclosure that's intended for the regular trash.
So let's talk about that loading area a little bit. Obviously, the trash enclosure there, dumpsters will go there to remove the typical trash. That's also where the deliveries that we spoke about of cannabis product and removal, that's where those trucks are gonna park as well, correct?
That's correct.
Yeah.
So the intended maneuver for the loading and unloading operations, as well as trash removal operations, is a truck, single unit box that will come onto the site and then go back into this particular space. From there, the security guards will meet them and handle that secure delivery through the back via the sidewalk that's provided to the back of the house. And there's a bulk space that occupies probably about a quarter of the overall floor area where the product is stored.
And that's the restricted area that we talked about, that rear door.
That's correct.
So no product is traveling through any public space, or it's really through that back sidewalk, right into a private restricted area.
That's correct. Escorted by the security personnel.
Okay. Lighting, can you talk a little bit as to the proposed site lighting?
Go for it.
Yeah.
The proposed lighting for this site will be serviced by 2 poles. There's generally located outside the 2 easement areas I described. The parking lot itself is not active. So the proposed lighting will feature, modern LED technology with back shields and cutoffs. So there's glare and such is being reduced overall. The height of the poles themselves are at 25 feet, complying again with city requirements. And there's a set of building mounted lights that's generally gooseneck style and intended more for accent lighting and aesthetic purposes more than site-wide.
Next, I want to talk a little bit as to the proposed landscaping. Can you speak a little bit as to what we are proposing on site?
Yeah, throughout the site, there's a mix of trees. Some of it's being relocated. There were street trees that was generally in the location of the proposed driveway. We're proposing to shift that around. But generally on all sides of the project, we're proposing a mix of trees, shrubs, and the stormwater basin. We're proposing to plant with a seed mix as well. And all of these species, generally they're native, they're not exotic or anything like that. They can be commonly found at local nurseries. And the same landscape architect that provided the plan for Wawa is the one that prepared this one. So it's going to blend pretty well between the two sites.
And obviously it'll take that vacant site now, and I think we're proposing somewhere in excess of 50, 55 plants, trees, shrubs, plantings, et cetera. Correct?
That's correct. Over 50 shrubs will be planted on this site. And then given the size of it, it's pretty substantial.
Okay, and then as we said, that'll obviously be maintained as part of the landscaping responsibility of the owner and the operator.
That's correct.
Okay, let's jump now to the architectural design of the building. If you can briefly describe to the board architecturally what's going on.
Yeah, of course. So this was, I believe this was submitted to the board, but I'll read it into the record. Is Verve Design Studio. This is the exterior elevations and also a floor plan. This was dated December 1st, 2023.
I'm sorry, December what?
1st.
1/23?
Correct.
You want to mark that one as A3?
Okay, so The exterior of the building, generally you're seeing the southern facade, which is the side facing the parking lot. That's gonna be where the main entrance is. Across the entirety of the building, you're gonna have a brick facade that's full height, all the way up to essentially the roof line and parapet line. That's gonna feature sort of a warm tone. And then along the corner vestibule where the entrance is, there's ample glazing to service and provide some light into the waiting area in the front entrance. And then that particular material will be a hardy plank, fiber cement board, hardy plank. That's going to be of a wood color. And then additionally, and that'll serve to sort of break up the rectangular box view of the retail store. And then to further break that up, there is a architectural bump out along the eastern facade. This is the facade facing the Wawa side, similar hardy plank material, brown color, that has a little bit of projection to it that will break those lines. Additionally, those gooseneck lights I spoke about during the lighting portion, that's proposed on both of the frontages, especially by the door, all of the frontages at the doors as well. It's going to provide some accent lighting and add some architectural and.
There'll be functioning lights, correct?
Correct, there are functioning lights, but it'll also add some artistic and aesthetic feel to the building. And then lastly, there is some small canopy awnings, projection cells, and further break up some of those lines. And then also just quickly speaking to the roof line, generally it's around 13 and a half feet tall, and then there's a full parapet that surrounds entirety of the building. That's at a minimum of 4 feet tall. So then speaking with the project architect, placing any rooftop units or mechanical equipment generally in the center of the particular of this building, with the parapet in mind, you won't be able to see the mechanical equipment.
Just to confirm, looking at the floor plan briefly, you mentioned here would be the entrance from the parking lot. That's where customers would enter. They would go into the sales floor after leaving the waiting area, and then they would exit along, I guess, the western side of the building, correct?
Correct. So the parking lot was generally in this facility, the front entrance. There's a waiting area. This yellowish color is the sales floor, the retail area. The red area of the building is the restricted area where the vault is, where the employees, the storage areas are. And then the exiting side from the retail component is going to be on the side. And then there's a sidewalk going either south back into the parking lot, into their cars, or north onto the Philadelphia Ave sidewalk.
And that on the northern part is where that restricted access is for product.
That's correct. Yeah, I'm generally pointing to the building that's located about 23 feet in from the corner, from the top left corner.
Okay, let's talk about signage. I know that was one area that I believe that we required some variances for, based upon some of the conversations we had with board professionals, Mr. McGowan. We've slightly tweaked the signage proposed. Can you speak a little bit to that?
Yeah, let me touch on the wall mounted signage to start. So generally there are 52 square feet. Currently they're proposed on all of the elevations except for the north elevation, which is one fronting Philadelphia. In discussion with Mr. McGowan and having reviewed his letter, decided to take the sign that was fronting the Wawa side and place that on the north elevation, which is now fronting the public street. And then generally will require variance from the number of signs, where 2 signs are permitted, 1 for each fronting the street, where there's 3 proposed. We'll need a variance for the size. They're 252 square feet each. So I believe the total aggregate was 50 square feet or so. And then lastly, on the height of them, they are 4.5 feet tall, whereas 2 feet is permitted.
And our planner will speak a little more as to the justification for those sign variances. We're also proposing a freestanding identification sign as well.
Yeah, that's correct. I'm just panning back over to Exhibit A2, which is the site plan rendering. The freestanding sign is proposed along the sidewalk back to Philadelphia Avenue with visibility from Atlantic Avenue and also on Philadelphia Avenue as you approach. Given that it's placed at the corner and our access is along Philadelphia Avenue, we felt that it's good for wayfinding. The size, the setback, as well as the height is all fully compliant with city ordinance.
Okay, and just briefly, I know you mentioned in passing some of the stormwater improvements. We are proposing a number of stormwater improvements. Can you speak to those?
Yeah, of course. So as I've already indicated, there's already 2 basins for handling the Wawa runoff that's on site. We're proposing 2 additional stormwater basins, one along to the east of the building. It's a small bio retention basin that's going to be seeded with a seed mix that's going to be Pinelands approved, generally low-lying grasses and bunch grasses and whatnot that provides a lot of stormwater quality improvements. And then that's connected in series to the basin along Philadelphia Avenue. That's an infiltration basin that's going to handle groundwater recharge and also our quantity reductions.
And these will all be compliant with the new DEP regulations.
Correct. These will be fully compliant with the latest DEP best management practices as well as the ordinance and also the Pinelands Commission.
Okay. You mentioned Pinelands, obviously we require a certificate of filing. We obtain that, it's been provided to the board. If we are able to receive approvals, we will then go back to Pinelands for a no-call letter, correct?
That's correct.
We're also on a county road. We have applied for Atlantic County, correct?
That's correct.
Okay, so we have county approval as well.
I'm sorry, I missed. County approval for what specifically?
So we, Aaron, you wanna?
Yes, there was a, let me pull it. There's a county favorable review letter, April 26, 2020.
Planning board, okay, it was just planning board. I just missed that word.
Gotcha. Let's talk about the board professionals review now.
Yeah.
You had a chance to review that prior to tonight's meeting?
I did, and reviewed, this is the Remington Vernick letter by Mr. McGowan, March 8th, 2024. I have reviewed all the contents in the letter and we can agree to comply with the comments within the letter.
Now, in your professional opinion as a professional engineer, you believe that this proposed plan and development satisfies the requirements for preliminary and final major site plan approval?
I do.
Okay. No further questions from Mr. Chairman.
Questions from the board?
You know, there's clay under there. You gotta break through it, or it won't drink.
Understood, as part of the wall development.
Wasn't the clay, it was a building foundation. we found.
Once you finish that, we have another job.
This one, we were fortunate, we did stormwater test pits here, all of these, there's 4 areas that were tested, they all received over 20 inches per hour vertical gradient. So, understanding there is clay in town.
People at the high school said the same thing, and it overflowed for 5 years until they fixed it.
Thank you.
I apologize. That packet was given us 2 months ago, I think, and I failed to bring that tonight after the live stream. Can you put the one that's on the ground, can you put that up?
Yeah.
The spot that's facing Philadelphia Avenue, which building is it? Is that the second one down?
This is the north elevation facing Philadelphia Avenue. So it's actually, kind of looks like the back of the house. What we're proposed to do in reviewing Mr. McDonald's letter is actually take the facade sign that was fronting Wawa and place that, I would assume generally in the middle of the building facing Philadelphia.
And what's behind the building? Is it a sidewalk? I mean.
What's in this
So
area?
that part of the building that facing Philadelphia Avenue, from the building to the grass, how much distance is that? Is it
Yeah, there's a sidewalk here, and then this building is set back 50 feet from the right of way line. And then there's a basin here.
I'm just curious. The only reason I'm asking is typically the back end of the building is where all the junk goes. And that's what's facing Philadelphia Avenue. So that's our entranceway to the city. It just seems odd to me that we would place the back of a building facing the street instead of the nicer side.
Yeah, understood. And that was something we looked at extensively. So recall I had the various easements going on, the utility easement that was associated with 6 Terrace, the stormwater drainage easement associated with the Wawa. The way we had to orient the site, the way we had to get the access to work was actually better to get the parking lot on the interior internal side. And then how that, kind of forced the floor plan layout out. Now the main entrance needs to be south facing. So then naturally, given the floor plan, you see the mass area that's actually restricted to from private or from public use. This whole entirety of the area is down the back, So
It's just not very pleasing to the eye on the
and
main part. I don't know if there's something we could maybe do to make that prettier.
To John's point, I think the back of the building naturally is what's facing towards Wawa. I mean, the site, your driveway comes off Atlantic, the site is kind of facing that direction. While the entrance was to the side, I think you probably be better switching the 4th elevation at the bottom of the second So that you have your sign and more decorative materials facing Philadelphia Avenue, which takes up the vast amount of traffic. And then you can, I mean, add another tree between those two trees and screen the backside that faces Wawa. You know, I think that it's sort of a goofy orientation, but to your point, and that's what we had to work with.
Yeah, so and this site is somewhat challenging in that it does have frontages on a lot of different roads. I would say that given the importance of Philadelphia Avenue, I think that will motivate the.
I think the
owner
view, the
operator.
view from Wawa and the view from Philadelphia Avenue is probably the most important.
Yeah.
So I've talked to the applicant, we're happy to, and it really what it would be, would almost be a switch here. So as Mr. McGowan just said, the portion that we originally proposed to face the Wawa parking lot would now face Philadelphia. And I think that adds a little more architectural flair on that roadway.
Yeah, but one of the things they changed before they even got here was they didn't have any public access from Philadelphia Avenue. And a year ago or so, when they were working on this, I said, well, you have to have a sidewalk from Philadelphia Avenue. That's like the main thoroughfare. So they do have a public connection coming from that side. But, you know, to your point of like somewhere has to kind of be the back of the building. I think that's really the frontage that faces Wawa. Because they can screen that, they'll have landscaping, they'll have all that, and then the rest of it either faces the street or faces the parking.
I mean, because you look at the Wawa building, there's really no back of that building either.
No, exactly, but they're trash enclosures on this side and they're parking on this side, and that's really the best you can do.
And where is the trash enclosure again?
Yeah, the trash enclosure is to the west immediately. Yeah.
So be on the railroad side?
Yes.
So, yeah, I don't think he specifically referenced when we went through it, but they'll actually need relief for a trash enclosure in the front yard.
Yep.
Because of the way that the building is oriented, that's technically the front yard.
Trash enclosure. They go now. I'm gonna let them knock it over. Go.
Well, I mean, it would be the fully fireproof enclosure, it's just where, that's the key.
Other questions? Is the building sprinklered? Does it have to be sprinklered?
I don't think so. The building of this size for retail use, generally it's not of that square footage where it needs to be.
But ultimately, it's a uniform construction code issue, and obviously we'll comply with what the requirements are to be constructed.
And if this goes up in smoke, do you really want to put it out? I'm sorry.
That, I'd like to now go to our professional planner, Mr. Steve Hall.
Hello.
I think I'm the last person.
You swear that everything you offer tonight will be the truth?
I do.
Thank you. And what is your name?
Stephen with a PH, Hawk, Hawk.
We follow each other around from town to town.
Yes, we do. And what else do you need from me?
Mr. Hawk, if you could just briefly, could you provide your credentials for it?
I've been practicing planning since 1988. I've been licensed in the state of New Jersey for 30 years. I've been an Certified Institute of American Planner since 1995. I worked for the city of Vineland for 28 years, reviewed almost 4,000 development applications during my time there, believe it or not. I was quite active. Been in private practice for 7 years. I've been probably before about 50 boards, over 100 applications during that time.
We accept this qualification.
Thank you, Mr. Chairman. So, Mr. Hawk, you heard us talk a little bit as to the proposed use and the bulk variances that are needed. And I guess my first question would be, do you feel that those bulk variances are justified? And if so, why?
Definitely. They both fall under the criteria of the C2 variance. I'm sure you've heard in your training and you've heard other planners and your solicitor talk about C1 and C2 type variances. C1 is the older type variance, and it's the only one that existed all the way up until the early 90s. The C1 variance is a hardship variance, or one that's based on shallowness or narrowness of the lot. The C2 variance came into play in the early 90s, and it's basically due to benefits. The zoning benefits of those variances outweigh the detriments. That's the test. The legislature thought that there were so many minor type variances that it was good to have that in the statute and have that justifiable through that process. There was a court case known as Pullen, P-U-L-L-E-N versus South Plainfield that said that the benefits that can be used for that test can come from the overall benefits of the site plan development, not just the benefits from the variance. And I think that's the case here, where you have overall benefits of this site plan development. What I see is definitely purpose A, which is under the purposes of zoning, the general welfare is advanced. I see Egg Harbor City kind of on a roll right in this area, given you have several modern sites now. You have Dunkin' Donuts, which has been, more of a modern site. It has grass. It doesn't have all pavement to the property edges. It has trees. It has bushes. Now the Wawa site is continuing and has continued with that. And now with this site, you have that modern development, subject to new stormwater regs, subject to having grass, bushes, and trees. So the general welfare is advanced by the fact that there's energy here, there's investment, and I think that's one of the nice purposes of that. You can even carry it further to that small park that was built by Egg Harbor City at the corner by the Firehouse Tavern. It's now coming through, and it's in contrast to the older sites of the 50s and 60s and 70s that didn't have any site plan design, that had pavement to the property line, pavement to the curb. So you're really seeing a really nice development in this stretch. No further degradation to the environment is another purpose. That's purpose J under the purposes of zoning. And you're gonna have 55 new plants here. And that's a nice feature. You're gonna have a bioretention swale. So that's also a benefit of this site. And then there's a more efficient use of the land. You definitely want this land used. This is smart growth. This is where you want your development. Highway commercial, the utilities are there, the roads are there, and it's county route. So I think those are the general overall benefits of the site that lend themselves to granting both the rear yard and the wall sign variances. The rear yard is kind of minor. It's 25 feet versus 30 feet required. But when you're looking at a rear yard or any kind of yard, you're looking at what's next to it. And what's nice about this is that the ordinance contemplates 30 feet on our side for a setback of a building. And then on the Wawa side, if it's deemed to be a rear yard or a side yard, it's gonna be contemplating another 30 feet. So the buildings need to be 60 feet away based on your ordinance. The Wawa is 90 feet away from the property line, so with our 25, you're gonna achieve a whole 115 building separation, and that helps. It's not like there's another building right up against it, and it gives it the space and the area. As far as the negative criteria on.
Before you get to the negative
Sure.
criteria, real quick, would you also agree that safe and efficient flow of traffic is also advanced here, particularly when talking about these side variances?
Oh, yeah, definitely. I agree. So with the negative criteria on the rear yard setback, it's basically, is what we're proposing, 25 feet versus 30 feet, is it out of character? Is it something where there's no other building that's close to a property line? We're actually setting a new prevailing setback along this stretch. Across the street on Philadelphia, it's the old style, the Teamsters building, the houses, they have no setback. They're right up against the sidewalk. They have zero. The Wawa and this development is setting a nice new setback. It's meeting the 50-foot criteria. There's some buildings, I think, over on Cincinnati Lane and Sixth Terrace that are close together. So having buildings close together, that old style development is the character of the neighborhood. I think we're breaking that, and the Wawa has broken that. And I think we're in, we don't have any substantial impairment of the zone plan and zoning ordinance because we meet every standard except for rear yard. As far as the wall signs go, they do provide a benefit in that they are good for wayfinding. They're good to provide traffic, an indication of how to get to this site, especially with the driveway being on Atlantic and not on Philadelphia. Having proper signage and proper wall signs is important. Now, your ordinance talks about having, I believe it's 40 square feet maximum for a wall sign. And we're gonna have 52 square feet. But the 40 square feet is something that is based on as a maximum, but your ordinance actually allows for you to have a sign. I think it's 1 square foot for every lineal feet of the building. Most buildings are 10 to 12 feet high. In our case, we're much higher than that. We're up in the 17 to 18 foot high if you count the parapet. So that leaves us with a facade that's bigger and more than what's normally contemplated and normally found. So our percentage of our 52 square foot sign is well less than the normal percentage that you see allowed. I often see ordinances where you're allowed 10% of the facade. In our case, we're gonna be at 4.5% roughly. So I think the variances in the wall signs are small in relation to the facades that are proposed. So that's why I think they're also very minimal.
Do you believe there's any substantial detriment to the zone plan or zoning ordinance for the proposed walls?
Definitely not, even though they exceed the square footage maximum, it's the size of the facade and it's the benefit that they propose with wayfinding that leaves them with no substantial impairment.
Chairman, I have no further questions for Mr. Hall.
Any questions for?
I have a question for the professionals of the board. I'm under the impression that you okayed and the council okayed one on 50 and one on 30. So are the applicants from 30 still trying to get their?
So I have that in my review letter, and I debated whether to just open with it or let them do the presentation and circle back to it, because I'm sure that there was more than one of you who were wondering why we're doing this. So I had this discussion with the city solicitor that there are 3 conditions for this conditional use. One is that the subject properties in the zone where retail cannabis is permitted, which this is. Second is that the number of uses permitted by the ordinance has not been exceeded, which it had, or which it's met currently. And the third is that the applicant has a conditional cannabis license from the state of New Jersey, which they testified they did. So we talked about the second condition, being the number of uses has not been exceeded, and the situation where we are currently. We had 2 applications simultaneously for the single license that existed. We were going to hear this one in the same manner, I suppose, that we heard those 2, that no one had secured their city license yet. That license was issued like 2 weeks ago. So we were already prepared to hear this, and I talked through it with the solicitor, and we kind of arrived at, we kind of have to continue to hear these, because as a license becomes available, the only person who is going to be eligible to get that license in a sort of competitive environment is someone who has their site plan approval already. So if we don't continue to hear applications for these, it sets up a situation where no one will be ready to essentially get any license that becomes available, whether the city adds another one to its ordinance, or it's done via the development plan, or the person forfeits their license or loses their license. So we kind of realize that we have to continue to let applicants come in and treat it as a conditional use, with the understanding that they will not be able to move forward without securing a city license at some point. So that's.
Okay, so the race is still on, is what you're saying?
Well, no, the city license was just issued, like I said, within the last 2 weeks to Atlantic Flower, the one on the 300 block of White Horse Pike. I don't know whether they're open or not, but okay. Well, I don't think so. No, the one in Philadelphia Avenue, that's been open for a bit. There's another one, White Horse Pike, there was Atlantic Flower, and there's the one in the liquor store.
Used to be Waddell's Liquor.
Well, so Atlantic Flower is at Waddell's. The other one is the one that's across from where Wawa used to be. Those were the 2 applications we heard at the same time. The one at the former Waddell's site at the 300 block, that's the one that just got the city license. So we ended up at a point where we had 2 people approved for their site approvals for this conditional use. One of them secured the actual license. If we don't hear any more of these applications, there's only one other person, like say the city were to open 2 licenses 3 weeks from now. There's only one person who can even compete for that license right now, because there's only one person with site approval to do so. So in talking over the city solicitor, we kind of have to allow people to continue to come in for site plan approval for this as a permitted use. And then if and when a license becomes available, they have the site approval to move forward. Does that make sense?
So in other words, the city has okayed 2.
One in the retail
Retail.
commercial and one in the highway commercial, correct?
So now the city can open up and get another one going if they prefer to do that. They have to change the ordinance.
Correct. The city, by state law, they are allowed to loosen the restrictions and add to the number. They are not allowed to reduce. So right now we have 1 and 1. It might be that way for the next 10 years. The city could, add another one 3 weeks from now or at the next meeting. But they would have to do that via ordinance. They'd have to advertise, they'd have to get the 2 readings, all that stuff. But again, there would be no applicants positioned to get that license if this board does not continue to hear these site plan applications.
Okay, so now I'm confused because the discussion that you and I have had
Yes.
is that this is a redevelopment plan.
So they are
And
in
that's
a-
the premise that we've been going under and what I've been telling the other
They-
applicants.
they are-
Call me all the time.
They are also in a redevelopment zone. We have a history going back many years. Tim has always considered that if an applicant comes in utilizing what he referred to as the underlying zoning, or the zoning that's there before we do this redevelopment, do a redevelopment plan. That was really the intent of the master plan, was to accomplish that goal. We only did a redevelopment plan because no one was coming in with that. So if someone comes in with something that complies with the original ordinance, that's great. That's what we wanted in the first place. So we reviewed this application as a permitted use in the highway commercial zone, because that would be the faster path forward for them, not having to wait for the city to go through and amend a redevelopment plan and either consider adding another license or not. So this, and again, up until 2 weeks ago, the city license had not been issued. So we were just going to hear this one, the same as we had heard the first two. Once the city license was issued, that's when we had an additional discussion with Angela of, well, we kind of do have to continue to hear these. They won't be eligible to get a license because it doesn't exist. But if and when it were to become available, they would be eligible to get it under the highway commercial zone. Separately, the city has the opportunity to create another retail cannabis license in a redevelopment zone. So if the city decides to do that for this property or any other property with a redevelopment zone, that revision to the redevelopment plan could contain the requirement that they comply with the conditions of the highway commercial zone instead of the original redevelopment plan requirements. So if that's the case, and the city decides to grant them a license via redevelopment plan, they'll already have site plan approval, which is consistent with the highway commercial zone. And then they would have an opportunity to get a retail commercial license via the redevelopment plan. So that's how we got it.
So to be clear, that's the direction that we had discussed that we were going to go.
Yes, but from a review standpoint, they would have had to put this applicant off multiple months for them to fully modify the redevelopment plan first, and then come back under the guise of the redevelopment plan. Instead, they could utilize the underlying zoning and come in as a conditionally permitted use and then continue forward. But again, it's separately from the redevelopment plan, in discussion with Angela, for both the retail commercial and for the highway commercial, I think it behooves the city and the board to just, like I said, to continue to hear these applications. Because let's say the guy on Philadelphia Avenue shuts down and forfeits his license tomorrow. If we don't hear any additional applications, there's no one positioned to take that license. Does that make sense?
It makes sense, but then you look at it the other way, where if council decides to grant this going, now you have 3 retail places in Culver City.
Correct.
But
I'm sorry.
No, good.
So I think it's a fair question, and certainly something that the applicant's eyes are open to going forward into this, that there is one license that has been issued, but I think the phrase that keeps being used is competitive and to compete. We'd like to try to compete for that. Now, that's not guaranteed, obviously. It's a question for the governing body as to whether or not they're going to issue any licenses. Right now, they've only issued 1. We understand that. I think we're okay with proceeding with that. Obviously, what you don't want is a situation where a license is issued and they sit on it, or it's rescinded for some reason, or you can come up with a lot of different reasons what may happen to that license. But I think what this allows for is competition for more licenses in the future, potentially, or keep it a single license that's later rescinded. But ultimately, they're governing body questions that the governing body is going to have to determine in connection with this proposed use. But we understand that right now, a condition of this board is going to be, you can't open up shop without a license from the city. And we understand.
And currently there's only 1.
Because you're saying that you can't open unless you get a license from the city.
Correct.
Right? But you guys are still applying for a license from the state right now.
You need
You're gonna be using that address and you're gonna be using, they require that you have consent from the municipality. So you're gonna say you have consent, you're gonna say you have a location. And after, if they award you, how are you not gonna come back and say, and claim detrimental reliance, that we spent so much money based upon this, even though what you're saying right here, at that point, how are you not gonna come back and say, we went through all your steps, spent all this money, and now you guys aren't gonna create a license or allow us to do a redevelopment plan or amend the current redevelopment plan so that we can get started?
So what I'm saying is we're going forward with our eyes fully open to exactly what you're talking about. And obviously, there's a record of this, of me saying that on behalf of the
I just wanna make
applicant.
sure,
So, so we're aware of that. To your concern, we're fully aware of that right now.
I have a question for, I guess, Ryan.
Yes.
So the board, we already created a zoning ordinance for where they can be located. You're saying we don't need to get involved again. It's up to council now if they want to add additional numbers to those two areas.
So anytime.
Highway and.
Yeah, anytime the city amends land use ordinance, it has to come back here for review and recommendation. So if they wanted to make that change, it would still come here for review and recommendation.
Okay.
But ultimately, it's a city policy on setting the number of licenses. Right now, there is only one. So as they've stated, they're fully aware of that. That license is taken. But again, in discussion with the solicitor, we sort of arrived at you need to be able to have other people who are qualified to assume that license if it's given up. If that place doesn't open, if they go bankrupt, if they forfeit the license, you need to have other people who are prepared to and qualified to get that license.
With the caveat that the applicant has to understand that he may or may not get the.
Correct.
That's correct. And we understand that.
Or the city could exercise the redevelopment option, right?
Yes.
I think that's what Lisa. was
That's what I'm saying. That's what I thought we were
Correct.
here for, and that's, you know, I wasn't privy to this discussion with our attorney.
The site plan review, it's just whether you're going to review it under the redevelopment plan requirements, which do not explicitly permit retail cannabis, or under highway commercial, which does permit retail cannabis as a conditional use. So the fastest path forward to get them through the board was to look at it as a permitted use in a highway commercial zone, which it is, and bring them to the board for a license which was still available.
Agreed.
Unfortunately, the meeting got delayed a couple of meetings. And had we heard this at the last month, that license would still be available. We wouldn't really have any of this discussion. But again, once that license was issued, we had the discussion of the way the ordinance is written and the fact that we need to have at least offer the potential for other sites to be eligible to receive a license if and when it becomes available.
So if something happens and Waddell's doesn't go through with theirs.
Yeah, they forfeit their license.
Does the liquor store get first shot at it? Or can this site?
But there's only one on Philadelphia Avenue. It's already open.
Yeah.
So this site is in the highway commercial zone, not the retail commercial zone. So even though it's on Philadelphia Avenue, technically, it's in the highway commercial zone. So it's not competing for the retail commercial license for the store that's already open. They're competing for the highway commercial license for a store that just received the license, but has not yet opened.
Well, but the other liquor store is highway commercial also.
That's correct. They had already submitted a city license application, which was returned to them once the other license was.
So they're out of the picture.
Or unless and until that license is forfeited or another license is introduced, correct?
And if Waddell's place never opens, then there'll be two of them back for the same.
Correct, then you would have the same environment where you have two people submitting for a city application.
Well, only one, because only one's on Route 30. He's wide open to council, changing everything and.
He's in the highway commercial zone.
Right, well, that's a different zone, so.
Well, no, we're talking about the Atlantic Flower one. Yeah, the Route 30 one that's in the 300 block, the one that just got their city license but isn't open yet. they're in the same zone as this property, the highway.
We didn't
commercial.
waive them on Route 30, two different zones.
Correct.
So my question is, will he need to have a license before they begin building, constructing?
Yeah, because they have not met the conditions of the use to move forward. They would have a site plan approval, but they would not be able to move forward without.
Well, they could build a building, couldn't they?
Well,
I mean, it
could,
wouldn't make
it would
sense
be
to
a
do it.
condition of the approval, though, that
To
we
be able
need
to
this,
open
yes,
Yes.
we have the license. I would say that if we don't, we'd have to come back. If we want to do something else with the building, it's a whole different use. I mean, it changes everything. Yeah.
Recording this meeting?
Got it.
Just come back. Talk over the other one, we'll interfere with the recording. All right, before we move on, you guys. It's just, it interrupts the recording.
These are live, just so you guys know. See right behind you, they're being recorded. FYI, just push the button right there.
You know, we're 14 minutes away from spring. Hang in there, 11:06.
All right, so this applicant heard earlier in the evening, I'm sure, this is our first meeting here. And as the mayor just indicated, there's been a lot of discussions between boards and different officials, and if I'm the one who at the end of this road has to come up with a motion, my head is now spinning. Are we all clear? And if I'm not saying something correctly, I'm gonna ask you to jump in. We're not approaching this under some redevelopment scheme.
Correct.
We're here for preliminary and final site plan approval with variances and waivers requested, and the one we're talking about now is the conditional use
In the
and
highway
to,
commercial zone.
huh?
In the highway commercial.
In the
zone.
highway commercial zone,
Mhm.
under which the applicant must satisfy 3 conditions or ask for a use variance, right? We're all on the same page so far?
Yes.
Okay. So that means we're before the zoning board right now, going back to what we talked about at 7 o'clock tonight, right?
No,
No?
because we're seeking conditional use approval. So our position is we satisfy all 3 of those conditions. And I know that what gets a little tricky here is 2 of those conditions are you will have a municipal license and you will have a license from the state of New Jersey. Now, when you read the conditional use standards under the MLUL, it says you will comply. What we are saying is we will comply with those conditions or we're not going to be able to build this project. We're not asking for relief from any of those conditions. Either we're going to comply with them or we don't have a project.
So condition number 1, the subject property is in a zone where retail cannabis is permitted.
Highway commercial is.
Right now, we're good with that.
Mhm.
Number 2, the number of uses permitted has not been exceeded. That is not true right now. There's 1 and 1's gone,
So
and you're hoping
So we're not seeking relief from that condition.
we're not there yet. I'm not even sure of the sentence I just said, let alone jumping to the next sentence.
Yeah.
The number of uses permitted by ordinance has not been exceeded.
right, the status of that changed about 2 weeks ago.
Okay, so right now, how many licenses are there?
There's 1 license in the highway commercial zone.
And does somebody have it?
One
Yes.
city license was issued approximately 2 weeks ago.
What?
That singular
Yeah.
license was issued about 2 weeks ago.
Got it. So one was created and somebody's got it.
Correct.
So the applicant is hoping
Mhm.
that there's another one issued and you get it,
Or that one is forfeited.
or that one is forfeited, right? Okay, and number 3, the applicant has a conditional cannabis license, that's in the works. Okay. Proceed. Oh, I don't know are we?
Ryan, did you have?
Yeah, I mean, you guys are.
Yeah, I know Ryan
Just for
was
a brief
done.
summation after the end public comment, but
Well, I don't know if Ryan was
Yeah,
done yet.
I'll go through. I mean, I think the applicant did a good job of summarizing the proposal. I'll just sort of highlight, I mean, we just went through at length, my section on zoning and completeness. Technical review, they are, as I noted, providing 19 spaces where 13 are required. The adequacy of loading space was addressed. Trash recycling, not something I highlighted, but they'll need relief from 170, 114M for the trash enclosure to be in what is technically a front yard in between the building and Atlantic Avenue. Though the trash enclosure is compliant as requested. They went through the signage requirements. Proposed freestanding sign is, I believe, now permitted in the zone. The way that it is written in the ordinance is horribly confusing. So I believe they do comply with the freestanding sign requirements.
Before, don't move on from signage yet, though.
Yes, they referenced the total square footage and the height as well, relief for those two things. Height where 2 feet is permitted and they have 4.5, and then a total square footage of 156 square feet where 100 is permitted.
And there are variances or waivers?
I believe that those would be design waivers. They're not enumerated in the zoning chart.
Okay.
Landscaping appears to comply, lighting appears to comply, architectural design standards appear to comply, but I'm glad that we switched that one frontage based on discussion with John. There's some stormwater infrastructure stuff that they have to clean up, but I don't think it'll impact the overall layout of the site. So I think we can handle that administratively afterwards if the board is comfortable with that. That's all that I have. Questions?
Any questions?
Yeah, again, I apologize, I can't see real well. There's no pass through between your parking lot and Wawa, is there?
No.
Okay, good. It just, people would speed through it, so.
Yeah, they'd have to walk around Philadelphia Avenue.
Yeah, and then no pedestrian or vehicular pass through.
Oh, well, they're gonna make it pass, so you might as well put a sidewalk in. I mean, being serious, because then the landscape looks horrible without a sidewalk.
Yeah, I actually brought that to their attention earlier. There's no good place to make a connection since it's parking stalls along the entire frontage. That's not where the basin is.
Yeah.
So I mean, ultimately, I think people will probably cut through here. You're not gonna stop that, but there was no good way to make it a formal connection.
Other questions from board members? Are we thinking about, we want to make a motion and have discussion?
I think we need to ask the public if they'd like to
Oh, I'm
weigh in.
sorry. Is there anyone? It's late. Is there anyone from the public wish to speak on this application? No one? Thank you. Close the public portion.
You want a motion now?
Yes.
Okay. As I indicated before, I prefer positive motions because they're easier to keep track of. This motion would be a motion to approve preliminary and site plan approval as presented this evening with the variances, and I'm gonna try to make this simple for you, as opposed to the last one. With the variances and waivers enumerated in Ryan's report. But I'm gonna ask that he specifically put on the record, or have Mr. Lario put on the record, what the sign. I think they're variances. I don't think it's a design waiver, but we can discuss that. I need the sizes because I'm not seeing, I'm not saying consistency in a bad way, but I'm not clear about what signs don't comply.
So
What's required and what's being requested, so I can make sure the resolution's right.
they have 3 of the same sign. The maximum height is 2 feet. They are proposing 4.5. They are allowed 2 signs because they have 2 frontages that face the street. They're requesting 3 signs. They have a total sign area of 156 square feet. Is that correct?
Yes.
Where 100 square feet is permitted.
I would ask that they be referred to as variances. Just, I know the testimony that was provided supported the variances.
I agree, I think
Yeah,
they're
it's fine.
variances. But didn't I hear, hold on a second. What did I hear? Was it Hawks? Did you say something about 40 versus 52 feet? Huh?
40 max per side.
Yeah. Versus You want 52. Right.
52, but it's for the first time.
That doesn't apply.
It doesn't apply, it doesn't apply. I'm just lost. Somebody's got to help me.
I don't think it does, but you might as well list that and just give relief from that.
So we can seek it in abundance of caution here. If
Okay.
it's not needed, that's fine, but I think
And what signs did that have to do with? The three of the same
The three-
size or
the
the two
building.
frontage ones?
The three buildings.
Yeah, I get that from 170-71A2.
So if I'm dealing with a maximum height of 2 feet versus the 4.5 feet that you've requested, what's 40 versus the 52?
That's square footage.
Square footage.
Yes.
so I think it's variance relief for the individual signs.
Telling you, blonde and 61, you guys, you're in trouble this year with me. Okay. I got it.
Okay.
I just, there were too many numbers and it's 11:01. Okay. Okay.
What's the sign gonna say?
I'm sorry?
What's the sign gonna read?
So it will be block letters, I think.
Yeah, then depending on what flag we run, we'll come in with the actual individual letters. block
What the
letters.
name of
The
the,
block letters will have, yeah, correct. Nothing flashing, nothing.
it's not gonna say Angeloni's
Nah.
or something.
That's not what my name on the lot stuff.
You could open the restaurant here.
That was it.
So we clear on that? The motion is for preliminary and final site plan approval with a conditional, I'm calling it conditional use. If they get all three things, they don't need the conditional use. They understand, and we'll make it clear in the resolution, they understand that they're here at their own peril, doubling down on what was said down here. And with the sign, all of the other variances, if there's one variance and the waivers referenced in Ryan's report, but we're gonna make it clear that the signage relief is also a variance.
And then it would be the rear yard and trash enclosure as well.
Yeah, they're in the report
Okay,
clearly.
just making sure.
Yeah, I mean, I could spend 20 minutes going through Ryan's report again, but I don't think anybody wants me to do that.
I'll make that motion.
Second, I'll second.
And roll call, and is this as a zoning board or a planning board?
Planning, because I was corrected that conditional use,
So
based on the discussion that the mayor and Ryan were having. Because if all three conditions were already met, it's not a zoning board issue.
So we now can have a discussion on that motion, right?
Mhm.
We just make sure we put it in writing what Ryan had, I don't know how you word it, on switching the building.
Yeah.
As long as it's part of that motion, then
Switching the east elevation with the north elevation, with revisions as necessary to accommodate those.
Switch east with west elevations,
East with north.
east with north, sorry.
Further discussion? Roll call down.
We're at a 45-degree angle, so you pick it north.
Mayor Petty,
Yes.
Mr. Peterson.
Yes.
Mr. Timbers,
Yes.
Mr. Walker,
Yes.
Mr. McKenna,
Yes.
Barth,
yes.
Mrs. Torres,
Yes.
Mr. Keener,
Yes.
Mr. Frick.
Yes.
Mr. Chairman,
Thank you, gentlemen.
thank you very much.
Okay, now we're gonna have a 40-minute report from the mayor on county. 2 minutes to spring. If there's no other comments from the board or public, anyone from the public motion to adjourn? I'm sorry.
We go off ball for the
Sorry about that, ladies. I did.
I seconded.
This doesn't happen very often, I assure you. Thanks, folks, I know it was a long night, appreciate it.
George, it's never. Don't let us scare you away, right? Usually we don't have it.
Yeah.